a video issue going on. What does that mean? We don't have video. That's a good thing. Right? Right. We'll take just a minute here as we we're good to go. We have audio, so we'll go ahead and just move forward in the interest of time, even though we have audio. So for those watching on YouTube, you're just hearing the sound of my voice. You're welcome. And hopefully we'll get that video started here pretty soon, and just bear with us as we work through some of those technical issues. But as mentioned before, we are back after our lunch break and ready to do the people's work. We have two additional cases from this morning to go through for review. The first one is Flouting versus State. If I could have Mr. Fuller go ahead and start with that one.
Yep, Chairman Odicott, members of the committee, Brian Fuller, LSO. This case, Flouting, addresses the scope and contours of the statutory right for a person to seek an independent chemical test after being arrested on suspicion for DUI. And what duties statute impose on law enforcement to provide or otherwise not hinder a person's ability to secure that independent test. By way of background, Wyoming is an implied consent state. So if you drive in Wyoming, you are deemed to have consented to a test upon arrest for DUI. This is 31-6-102. Upon arrest under that statute, a person is subject to any chemical tests that law enforcement requires, subject to various procedures and limitations. This is 31-6-102 A2C, but law enforcement must advise a person arrested for DUI that if the results show that the person is under the influence, the person may be subject to criminal penalties and subject to a driver's license suspension, and that after undergoing all required tests, the person may go to the nearest hospital or clinic and secure additional tests at the person's expense. Similarly, statute also provides that the person who has been tested may, at the person's own expense, have any qualified person of his choosing administer a chemical test or tests in addition to any law enforcement administered test. And the failure or inability to obtain an additional test doesn't preclude the admissibility of a law enforcement test. This is 31-6-105D. Both of those statutes that I just read are reproduced in the accompanying memo on page 2. So in this case, the defendant was arrested by a police officer who informed Flouting of his rights and obligations and told him that after all required tests, he could be taken to the nearest hospital. After some discussion and disagreement, Flouting completed a breathalyzer test at the detention center that showed that his blood alcohol concentration exceeded the legal limit. The officer at that point reiterated that if the appellant didn't agree with the test results, he could be taken to the local hospital for a blood test. The officer also told the appellant that the test cost $150. The appellant requested the independent test, told the officer that he had enough money in his wallet to pay for it. But then when asked where his wallet was, the appellant told the officer that the county was required to pay for the test. The officer called the hospital to see if it would perform the test and bill the appellant. The hospital responded that it would not perform the test without receiving payment first. So it would not bill or perform the test without receiving payment. The appellant ultimately told the officer that he didn't have the means to pay for it, but reiterated again that the county was required to pay for it. Since he could not pay for the test, the officer didn't take the appellant to the hospital for the test. Instead, he left him at the detention center. The appellant was subject to a driver's license suspension. He argued during a contested case hearing over that suspension that he wasn't afforded the opportunity to obtain an independent test as required by statute because the officer unreasonably interfered with his attempt to secure that independent test. The hearing examiner disagreed and upheld the suspension, and the district court affirmed that. Then on appeal to the Supreme Court, the appellant argued that 31-6-102 A2C required law enforcement to drive him to the nearest hospital for an independent test, even though he had no means to pay for it at that present moment. And even though the hospital said that they would not perform the test without advance payment. The appellant also argued that law enforcement interfered with his right to an independent test by not helping him find his wallet, by not giving him access to a phone to arrange his own test, by not transporting him to the hospital, where the appellant contended that had he been transported, he could have attempted to persuade the hospital to administer the independent test, despite the lack of funds for an advance payment. The Supreme Court disagreed and affirmed, and the court, relying on a previous case that concerned 31.6.102 A2C and 31.6.105 the court noted that those provisions were clear and unambiguous, that a person undergoing a law enforcement test has a right to be informed that he can obtain his own test. And if he requests that test, he may go to the nearest hospital or clinic to seek one. And then the court quoted, and I'll read it from the opinion, if the legislature intended to obligate law enforcement officers to further facilitate a test, it would have said so. And the court noted that it is not an officer's responsibility under statute to ensure that the person obtains any test. In this case, the court concluded that law enforcement didn't prevent the appellant from obtaining an independent test. The court also, in response to another argument from the appellant, noted that substantive due process doesn't impose a duty on law enforcement to voluntarily arrange for independent testing, so long as law enforcement doesn't actively thwart a person's attempt to make those arrangements. So in this case, the potential considerations for the committee would be whether statute should impose a more affirmative duty on law enforcement to facilitate an independent test, and if so, what duties should be specified or imposed in statute. And another consideration may be whether the inability to pay for a test in advance should preclude a person from being able to exercise the right to an independent test under statute. With that, Madam Chairman, I'll stand for questions.
Mr. Fuller, excellent job. Questions for Mr. Fuller? Representative Swanitzer?
And it's more of just a criminal question for whoever. So there's a duty for law enforcement to release someone if they wanted to go to a hospital to get this test completed. There's no duty that the police would have to drive them there, but I have to think there can't be a way that someone can say, I'm going to go walk to the hospital and get an independent blood test, and they've been suspected of a crime, and the police would just say, all right, we'll see you when you get back here in an hour. So I guess I need to understand there is an affirmative duty for the law enforcement to provide transportation to a medical facility for this test, or there isn't. And I can't find that in the law, nor did it make sense to me in the write-up.
Mr. Fuller, if you know.
Yeah, Madam Chairman, Representative Swanitzer, the statute is admittedly silent on the method of transportation. I would assume, just as a practical matter, that law enforcement's not going to release someone who has been placed under arrest to secure their test at their leisure or will.
Additional questions, follow-up? All right, seeing none. Committee, any final questions for Mr. Fuller? All right, we'll go to public comment on this bill. Is there any, or on this case, any public comment? All right, seeing none. Committee, further discussion. Take action, not take action? If not taking action, can I hear from some of the committee members as to why? Senator Kolb?
Thank you, Madam Co-Chair. No, I believe we should codify this and clear up any confusion there may be, so we're clear to the public on who's responsible or not responsible for, say, a testing they request, and just make sure that we cover our law enforcement folks and I don't know, clean up any ambiguity. Thank you, Co-Chair.
Representative Oakley.
Thank you, Madam Chair. I mean, the advisor says, you know, at your own expense. I don't see anything here that I feel compelled to act.
All right, committee, thanks. We'll move on to the next case. Schneider versus State.
Madam Chairman, members of the committee, this case addresses whether Wyoming statute requires a court to hold a hearing when a person seeks and makes a prima facie case for relief from the requirement to only operate vehicles equipped with an ignition interlock device for the remainder of that person's life. By way of background, when a person is convicted of DUI, statute may require that person, depending on the circumstances of the offense, to drive only vehicles equipped with ignition interlock devices, basically a breathalyzer attached to the vehicle that you have to successfully blow into before being able to turn on the vehicle and operate it. The requirement depends on the conviction. For first conviction, if the blood alcohol concentration is greater than 0.15, or if it's a subsequent conviction, the length of time depends on the type of conviction as well. Relevant here, if a person is convicted of a fourth or subsequent DUI, the person is required to comply with the interlock requirement for the remainder of the offender's life. This is 31.5.233 F5. That's reproduced on page 2 of the accompanying memo. That statute, though, also provides that a person can apply to the court for removal of the device 5 years after the date of conviction, and then can reapply every 5 years thereafter. The court may, for good cause shown, remove the requirement if the offender hasn't subsequently been convicted of a DUI offense. And so really there's 3 requirements that a person must meet in order to receive relief from the lifetime interlock requirement. So first, at least 5 years must pass after a DUI conviction. Second, the person cannot have had a subsequent DUI conviction. And then third, the person must show good cause as to why the requirement should be removed. So in this case, the appellant had multiple DUI convictions and was required to have an interlock device in his vehicle for life. The appellant applied last June to have that requirement removed. In his petition, he asserted that 5 years had passed since the conviction. He had not had a subsequent DUI conviction, and then also asserted that he had been sober, took his sobriety seriously, and was no longer a risk to public safety. The state opposed that motion. The district court in this case denied the application without explanation, and the district court declined to set a hearing. The appellant appealed, and he argued that the district court abused its discretion by denying his motion without holding a hearing. And he further asserted that 31.5.233 F5 requires the court to hold a hearing if a person meets the first 2 requirements. So the 5-year length of time has lapsed and no subsequent DUI conviction. The Supreme Court agreed and reversed the district court. The court had noted that neither the legislature nor the Supreme Court had defined what constituted good cause for purposes of 31.5.233 F5. In this case, the court relied on a New Mexico decision that held that to show good cause, an applicant must show that he no longer presents a threat to public safety if given an unrestricted license. And in that New Mexico case, that court had stated that if their legislature had intended that people receiving numerous DUIs must maintain an interlock device indefinitely, regardless of good cause, the legislature could have drafted that statute to say so. So here in this case, the court similarly held that a court cannot deny an application to remove an interlock device based solely on the number of convictions that the person has. Then the court also stated, and I'll read this from the opinion, the legislature intended that an applicant be entitled to a hearing to make a good cause showing and provide relevant evidence. The appellant also argued in this case that the district court erred in that the district court was required to make findings of fact and explain its reasoning in denying its application. For this argument, the court concluded that 31.5.233 F5 does not require a court to make findings of fact, but then further stated that in, like many other situations, findings of fact can provide a basis for meaningful appellate review. In terms of considerations for this case, for the committee, if it desires, one question would be whether change is needed to clarify whether a hearing is or is not required for a petition for relief. And if so, what limits or requirements should be specified in statute for that hearing, whether a specified number of DUI convictions should preclude a person from the ability to seek discretionary relief from the ignition interlock requirement. And then finally, whether a district court must articulate findings of fact in deciding in granting or denying an application for removing the interlock device requirement. With that, Madam Chairman, I'll stand for questions.
Thank you, Mr. Fuller. Questions for Mr. Fuller? Seeing none. Any public comment on this case? How's the afternoon? All right, well, public comment is closed. Representative Provenza.
Thank you, Madam Chairwoman. I guess one of my questions is what's the cost incurred? Because my understanding is it costs money to go have the interlock serviced at however many periods in a year or so forth. So I'm just kind of some of that logistical information as to what maybe the burden is of having an interlock system for life.
Anyone in a position to answer that? It's my recollection that it's hundreds of dollars. But I couldn't be more specific than that. Representative Oakley?
Thank you, Madam Chair. I think it's a similar idea, but I guess just in looking at this, so we make a law that said you've had 4 DUIs, 5 DUIs, we're going to have a lifetime restriction. And then we turn around and say, oh, but then you can have a court hearing and not have a lifetime restriction. I mean, at some point, we've discussed a lot that our courts are crowded and, you know, how busy we are. And I guess just from a policy standpoint, either it's a lifetime restriction or it's not, and maybe that's an easier way to go.
I do think that's the question for the committee to consider, is whether or not there should ever be relief from a lifetime requirement to have the ignition interlock device. 10 years sobriety, 20 years sobriety, at what point does the interlock device become challenging, or is it truly a lifetime? Good discussion. All right, Representative Provenza?
Yeah, thank you, Madam Chairwoman. Maybe there's a provider in the room that can say how, if there's a certain length of time, we know with, say, recidivism, that after a certain period of time, the likelihood someone's going to go back to prison, it very much lowers. And so is there a period in time with people who are struggling with substance abuse disorder where they then they're sober for 10 years and the likelihood of them having a relapse is so minimal that we should consider not having that lifetime sentence?
Senator Cole?
Thank you, Madam Co-Chair. When it comes to 4 DUIs, driving is a privilege. And I think if you've proven yourself to be habitual, I think there's probably a point in time you say no more. It's a danger to the public. It's a danger to my family, your family, everyone else out there. I think there's consideration should be given, as it was in the past, to make it a lifetime ban without a interlock device. And that's the privilege, the price you have to pay for what you've done in the past. Thank you, Madam Co-Chair.
Representative Craigo?
Thank you, Madam Chairman. So I guess I'm looking at this a little bit differently than maybe some of the former speakers here on the committee. I don't know if it's, as I'm looking at this, I guess the question in my mind and what the case really had to do with was, does a judge have to have a hearing? I mean, that's the question. Does a judge who knows this person that's been in his court 10 times have to have a hearing every 5 years, or can he say, we're not even going to waste we're not going to waste an hour of the court's precious time to deal with the hearing? And so, I don't mind the statutes as written, other than it is unclear on whether or not, based on the Supreme Court's opinion, whether we need a hearing every 5 years, every time somebody petitions the court to have the interlock removed. And I'm of the opinion that the district court's in the best position to decide whether a hearing is necessary or not. And so I'd prefer that if we're going to add language to the statute, that it says that the court may have a hearing at their discretion.
Is that a motion, Representative Craigo?
It is.
All right, moved by Representative Craigo, seconded by Representative Washut. Further discussion? All those in favor, please say aye.
Aye.
Any opposed? No. That motion has passed. Further discussion on the bill? On the motion, on the case? All right, seeing none. That case is complete. And with that, we have wrapped up our topic of Supreme Court opinions.
Madam Chairman, we may be able to, we may have a fix for the video. It
Sure.
would require a brief 4 to 5 minute break if you wish.
I think it's a good time before we start this next topic to go ahead. We'll take a quick break. I know it's important for many of the people here. right, we will call the meeting back to order after that brief recess. Looks like our technical difficulties are resolved and we're back on screen, and audio and video are all working as they should, just in time for our big topic of the afternoon, which is treatment courts and substance abuse issues. With that, we'll go ahead and start with a broad overview from LSO Attorney Brian Fuller. Mr. Fuller?
Yep, Madam Chairman, members of the committee, you should have a summary in your supplemental materials, the packets that were at the back of the room yesterday. It's 15-01 for the online materials. And just a summary of the Court Supervised Treatment Programs Act, which generally authorizes treatment courts, also known as drug courts in Wyoming. In 2009, the legislature enacted the Court Supervised Treatment Programs Act. In that bill, the legislature recognizes the need for treatment programs to break the cycle of abuse, of substance abuse and crime as a result of substance abuse. The legislature also recognized the need to facilitate court supervised treatment programs to provide sentencing options that combine judicial supervision, probation, substance abuse assessment, testing and monitoring, and treatment, as well as aftercare for substance offenders. Under the Act, the Department of Health is the entity responsible for overseeing the program. And for entities that want to establish a court supervised treatment program, the Department of Health is ultimately responsible for reviewing and then approving or denying applications for the creation of a treatment program or a drug court. Under the Act, eligible applicants are a city, a town or a county, a tribal government, or a nonprofit organization. Applicants that want to operate a program must create a program team that would meet and discuss participants in the treatment program or drug court, as well as providing updated information and progress reports on those participants. The program team must include a judge, a prosecuting attorney, a criminal defense attorney or a guardian ad litem attorney, a treatment provider, a probation officer, a program coordinator for that particular treatment program, and then other persons that the participating judge identifies as helpful and necessary. Applicants must be accredited and certified as a treatment provider, or in the case of a governmental entity that's applying, they must have an agreement with a nationally accredited and certified provider. Applications for creating a program must include the list of treatment services that the program would provide, the identity of the participating judges, and a plan for the participation of those judges, consistent with rules that the Department of Health and the Supreme Court have adopted, as well as any other information that the Department of Health requires. Final determinations on applications are made by a panel that consists of the Attorney General, the directors of the Department of Health, Department of Corrections, and Department of Family Services, the chairman of the Governor's Advisory Board on Substance Abuse and Violent Crimes, and the state public defender or their designees. Applicant requirements, the applicant must agree to serve as a contracting agent for all of the program's contracts. The employees of a drug court program must be employees of the applicant. Judges, Department of Corrections personnel, and judicial branch personnel under statute cannot be program employees. An applicant must manage all program funds under a contract between that applicant and the Department of Health, and the applicant's responsible for taking care of program billing. The Act requires the Department of Health to promulgate various rules, including formulas for funding from the Court Supervised Treatment Program account, as well as rules for a requirement for a local match for the program's costs. There must be rules for requirements for drug court participants to contribute financially to their own participation in the program. And then finally, just rules regarding program requirements, operational standards, as well as data collection and maintenance. For funding, the Act created a court supervised treatment program account. There's a surcharge of up to $50 on any person who is convicted for an offense under the Controlled Substance Act or a DUI offense. That surcharge also applies to those persons whose prosecutions are deferred or who participate under a diversion agreement. Statute does give the court the ability to waive the surcharge for good cause shown or an inability to pay. The department can accept gifts, grants, federal funds, other contributions for deposit in that court supervised treatment program account. And then individual programs can also obtain or provide their own supplemental funding, but they must report those funds to the Department of Health. The Act also provides for program requirements. So a program, an applicant must establish a system that ensures that participants are provided with appropriate treatment services that the Department of Health certifies. They must determine the type and duration of treatment services, keep records confidential, and comply with federal law regarding record keeping. Must strive to establish an adequate continuum of care, including adequate support services for aftercare. They must strive to provide appropriate treatment to participants who have a co-occurring diagnosis of substance abuse and a mental health disorder. They must enter into memoranda of understanding with treatment providers, must require accurate and reliable substance abuse testing of participants, and then provide those results to the program team as soon as possible. Applicants must maintain and report information to the Department of Health as required. And then finally, under statute, any judge can act as a participating judge in a treatment program subject to rules applicable to those judges that the Supreme Court has promulgated. Currently, there appear to be 16 programs around the state. Some focus only on adults, some only on juveniles. Other programs broadly provide services for both. In terms of individual participants under one of these programs, a judge may refer a substance offender to participate in a program. A municipal judge can require participation as a condition of probation. And then the Board of Parole is authorized to require a parolee to participate in drug court as a condition of parole as well. Otherwise, a person may participate in a drug court program if that person has been charged with a substance-related offense and has pleaded guilty or no contest, or has a deferral or consent decree. There must be a substance abuse assessment that reveals that the person is in need of treatment. The referring judge has to have reason to believe that the participation would benefit the person by addressing the person's substance abuse. And then for juvenile cases involving parents, the judge would have to have reason to believe that participation by a parent or guardian would be in the child's best interest. Participation in a program is only with the consent of the judge and the participant, and it is conditioned on the particular program team accepting that person into the program. Each participant is required to have a written agreement with the program team that outlines the terms and conditions that each participant is required to meet. Participation in the program is not a right or an expectation. Participants are required to submit to frequent, random, and observed substance use testing. Participating judges can grant reasonable incentives and impose sanctions under that written agreement. And then expulsion from the program is possible at the judge's discretion, but can only occur after there is a hearing and after giving the participant an opportunity to respond at that hearing. Generally, graduation from the program is after 12 months and the person is abstained from substance abuse. Also, generally programs would require that the participant pay any fines or fees and then demonstrate that the person can live a clean and sober lifestyle. That's a pretty quick and broad overview, Madam Chairman, but I'm happy to stand for questions.
All right, questions for Mr. Fuller? Committee, we'll be making some pretty, the proposal is that we make some pretty substantive changes to how our drug treatment courts work in the state, both funding, which we authorized last year, but then also how they're located. As you heard Mr. Fuller identify, they're currently within the Department of Health. And so we're going to hear from the Department of Health here today and also our courts to understand if that's really working or making the most sense. So I want you to kind of keep those questions in mind as you hear the testimony instead of kind of just this is what it is to be listening for those kind of questions and those types of concerns. So with that, we will ask for the court to come forward, and as identified on the agenda, we'll ask folks to come forward as listed on the agenda that you can see. So with that, look for Ms. Butler, if you could please come forward again. Mr. Burningham, a favorite. And is Justice Fox online? Wonderful. And Judge Christensen, it's a good group of folks here in front of us. Wonderful to see you here this afternoon. Justice Fox, as soon as we can see you, the floor is yours.
Can you hear me? Oh,
We can hear you.
Thank you, Madam Chair, members of the committee. Appreciate you letting me appear by video and taking up this important topic. I have been very interested in treatment courts for a number of years, and we've worked closely with the Department of Health and also the Department of Corrections to try and enhance some of the courts we have and to look at possibly expanding them to areas where they don't yet exist. You have, I think Judge Christensen is there. He runs a treatment court. The interesting thing about treatment courts is the judges who have them are very passionate about them and how effective they are for the participants, but they're also good for the communities. And as I travel around the state, I hear from county commissioners and law enforcement that they love their treatment courts as well, because they see results for the treatment court participants that are good for their communities and also actually save them money when you compare with the cost of incarceration. So, but I think the question before you is not the value of treatment courts, but where they should reside. And since we saw this topic as an interim topic for you, we've taken a hard look at it. In most states, treatment courts do reside in the judicial branch. And I think there's a good reason for that. And that is primarily that the keystone of the treatment court team is the judge. And judges don't respond all that well to the authority of executive branch agencies. The other thing that's important is that because it's more in our wheelhouse for the judicial branch, we have a passion for it and the resources for it. I think that we've already, and Ben Burningham will talk to you a little bit more, no matter who manages treatment courts, we're more deeply involved recently in providing training, which we're actually doing this week for treatment court, not just judges, but all the participants. We'd like to be in a position to have better quality control, training, and especially to obtain grants. There are a lot of grants from federal agencies for treatment courts that, for good reasons that perhaps Director Johansson can tell you, health doesn't pursue very aggressively. We would like to be able to do that, to get more money, better funding, so that we can have more treatment courts in more places and have more participants in the places where they do exist. So that's my quick summary. I really appreciate your attention to this topic. I have no complaints about our collaboration with the Department of Health, and we've worked really well with Dan Shannon at Department of Corrections. But I just think the judicial branch is probably better suited to administer, oversee, and fund or help fund these programs. So I think the people you have there in the room can tell you more of the details, but that's my overview. And I thank you for looking at this topic, and I would take any questions.
Thank you, Justice Fox. Questions for Justice Fox? All right, with that, we'll go to Ms. Butler. Ms. Butler, good to see you again.
Madam Chair, Mr. Co-Chair, members of the committee, my name is Elisa Butler. Again, I am the State Court Administrator for the Judicial Branch. I really am here to answer any administrative questions you may have, but the two people sitting on either side of me are the real experts here. Ben Burningham has originally came to us as Director of Chancery Court, and he did that so well that we asked him to take on additional duties of Chief Legal Officer in the administrative office. So he has been working really hard on treatment courts over the last few months and has a lot more knowledge and information and has a nice little PowerPoint for you all to review today. And then you all know Judge Christensen here, who is the circuit court, one of the circuit court judges in Natrona County, and has some vast experience with treatment courts. And so I'm going to rely on these two people to take you through some of the history and information that they have on treatment courts.
Wonderful. As we transition to that PowerPoint, I'd like to just acknowledge the amazing chairman of the Senate Appropriations Committee, Senator Drew Perkins, is here with us today. I failed to acknowledge him here before lunch, and We're so glad to have you here in the room with us, Chairman Perkins. Great to see you here. I think a former chairman of this committee. All right, Mr. Burningham, please proceed.
Chairman Nethercutt, members of the committee, my name is Ben Burningham, Chief Legal Officer at the Wyoming Supreme Court. I really appreciated the overview that Mr. Fuller gave, but what I would like to do now is both zoom in and zoom out. Zoom in by discussing the exact role of treatment court judges, and then zoom out by discussing the administrative structure that some of our sister states use. I think Judge Hudson of the Mississippi Supreme Court said it well when he said that a drug court is a judge-driven court. And this sentiment is shared by national experts. There's an organization called the National Drug Court Institute that provides training to drug courts, and it has published a bench book or a manual for how treatment courts and drug courts should proceed. And in its manual, it notes the centrality of the judge and the driving force of the judge. And it gives 5 key roles to the judge: the role of leader, communicator, educator, community collaborator, and institution builder. I'll briefly touch on each role. As you heard earlier, a drug court is made up of a team of professionals: prosecutor, defense attorneys, treatment providers, probation agents, supervision, a coordinator. But the quarterback or the leader of this team is the treatment court judge. He or she is the one who directs the activities of the treatment court. And as a leader, the treatment court is the communicator, the one who is responsible for facilitating communications between drug court members, but also, and most importantly, the one who is responsible for being the face of the treatment court, the one who awards incentives to treatment court members who are complying with the requirements, or the one who delivers sanctions for those who are struggling to comply. And this ongoing opportunity to be held accountable by a judge in a black robe in a formal courtroom really seems to be the main driver of success in treatment courts. A survey noted by the National Drug Court Institute showed that 80% of participants mentioned that they would not have continued in the treatment court program absent that opportunity to regularly appear before a judge and be held accountable. The treatment court judge is also the educator, and this National Drug Court Institute manual puts the onus on the treatment court judge to not only become educated and trained on treatment court matters, but also to ensure that all members of the team receive training. And for the branch, this has been a bit of a struggle because we do not have funding for training. But this year we are piggybacking on Wyoming Highway Patrols and the Governor's Council on Impaired Driving. They are holding a summit, a traffic safety and prevention summit this week in Laramie. We've piggybacked onto that summit. We'll be providing treatment court training to all of our treatment court judges who are available and the team members. We have some national experts coming to provide training, and we've noticed that these training efforts that we've engaged in have really re-energized our treatment courts. The treatment court judge is also a community collaborator, the one who brings these important professionals and different team members together to run a proper treatment court. And then lastly, the treatment court judge is the institution builder, the one who builds the court, ensures that it's running properly, ensures that all the key parts are there. And the National Drug Court Institute is not the only national organization to recognize the centrality of the judge in the treatment court process. There's another organization called the National Association of Drug Court Professionals, and it produced a document called the 10 Key Components. These components define what a treatment court really is, and the NADCP published this on behalf of the Department of Justice. And these 10 key components are even referenced in Wyoming's treatment court statute. And component number 7 recognizes the role of judge as leader and recognizes and underscores the importance of a judge having ongoing interaction with treatment court participants and showing that someone in a position of responsibility is there to hold them accountable and is concerned and invested in their progress and their treatment. So now that we've zoomed in some into the central role of the treatment court judge, I'd like to take a step back and look at what some other states do in terms of how they organize and structure administratively their treatment courts. And I'd be lying to you if I told you that we did a 50-state survey. We have not, but we did discuss this matter with some national experts and took a look at some surrounding regional states to look at what sorts of administrative models are out there for state treatment courts. And we identified 3 main models. One model is the model used here in Wyoming, which is a Department of Health centric model. This model is rare. Nationwide, we only found 3 states that use this model: Oklahoma, Washington, and Wyoming. Another model we found is a model where the Supreme Court and Department of Corrections share administrative and fiscal responsibilities and duties. This model is more common than the Department of Health centric model, but it's still not the predominant model. The predominant model is the model where all administrative and fiscal control is consolidated within a state Supreme Court. And this is what most of our neighboring states use: Montana, North Dakota, South Dakota, Nebraska, and New Mexico, to name a few. And within this majority model, there are a few different approaches, and I'd like to highlight 2 of those approaches: the approach of Montana and the approach of New Mexico. But before we do that, let me briefly address the limited role of the judicial branch in administration of treatment courts right now. Despite the central role of the judge, the only administrative function under the current statute that the Supreme Court and the judicial branch plays is to promulgate rules that govern treatment court judges in treatment courts. All administrative control over the programs, fiscal control, this all resides within the Department of Health. In a state like New Mexico, in contrast, all administrative control is consolidated within the state Supreme Court, and all treatment court documents operate only by order of the state Supreme Court. And that court sets standards that govern not only practice and procedure within the court, but also the program administration. And these standards are administered, or better said, these standards are enforced through a certification process and a peer review process. And then at the state Supreme Court in New Mexico, you have centralized data management and analytics to ensure that treatment courts are operating effectively and approving. New Mexico's model is to have a strong centralized staff that can do things like fiscal management, data management, certification, ensuring that all services are there to assist treatment court members, not only getting into the program, but after they graduate. The funding in New Mexico, each district court that operates a treatment court sets aside a part of its budget to fund those treatment courts. And then the state Supreme Court supplements that funding and also pays for administration. And in New Mexico, the Supreme Court receives roughly $3.8 million per year to administer its treatment courts. And then it supplements that state funding with these federal grants and this federal funding that Chief Justice Fox referred to in her remarks. Montana is very similar. Treatment courts are dockets of existing district courts, and these operate under the control of the state Supreme Court. And the Montana Supreme Court sets standards, and again, it enforces these standards through a peer review process. The difference between a state like Montana and a state like New Mexico is the staffing. In New Mexico, you have a strong central staff of 8 persons. In Montana, you have a single statewide drug court coordinator who was at that centralized staff, but then all the local drug court coordinators are also employees of the state Supreme Court. So in Montana, you have 21 district court coordinators who are employees of the Supreme Court, and then 1 statewide drug coordinator who's also an employee of the Supreme Court. Whereas in New Mexico, you have 8 centralized Supreme Court employees, and then those local coordinators are employees of the local district courts. So that I hope that this overview has given you a sense for how treatment courts operate in other states as you consider this issue. And of course, the branch, as Chief Justice Fox mentioned, is supportive of any efforts to make our treatment courts more robust. We believe moving them into the Supreme Court allows us to earn greater efficiencies and make our Supreme Courts more robust and more effective for the people of Wyoming.
Representative Washit.
Thank you, Madam Chair. My question has to deal with why Wyoming went down this approach in the first place. Do you have any of that early organizational history that led the decision-making to place this within the Department of Health? Was that once a model that was more popular than it is today, or how did we end up with this model that we have today?
Mr. Burningham, if you know.
Chairman Nethercott, Representative Washit, I don't know the precise history of the reasoning behind the initial organizational structure, but I do know that this model never has been a predominant model.
Judge Christensen, do you recall?
Madam Chair, Co-Chairman Olson, members of the Joint Judiciary Committee, Brian Christensen, Circuit Court Judge in Turner County. Yeah, probably. I keep forgetting things, but I was there at the planning and implementation. I was prosecuting these cases in the 80s before the feds even declared war on drugs. And it was a judicial thought at that time. It was not a historical court function versus those of us on the front line and the judges that were dealing with these versus is it a judicial function or is it something outside the judiciary? Wyoming was one of the first states to implement statewide statutory rules and regulations. And you'll see there's I think a repealed section on drug courts in 2009. We went to court supervised treatment programs. Early 2000s, the Wyoming, and I argue with my friends from Kentucky, was the first state. Kentucky believes they were the first state. So that's where there was nobody to follow. We created the wheel. We were like one of the satellites for drug courts nationally at that point. Though that is kind of, there's other drug courts, in states now that are leading the way in how these programs operate. Thank you, Madam Chair.
Thank you, Judge Christensen. Co-Chairman Olson.
Yeah, thank you, Co-Chairman. Ben, as we go down this path of moving the treatment courts under the Supreme Court, you highlight two models. The one where you've got the central office basically, and the other where we have 21 different offices coordinating under a central officer. What do you think? Does the court have a preference on one, what is most workable, at least in terms of a transition? But I want to know more importantly, in a long-term goal, what should it look like?
Chairman Nethercott, Co-Chairman Olson. Our preference would be the New Mexico model, just because we don't have the administrative capacity to onboard 21 treatment court coordinators and an additional centralized statewide coordinator. We think we're in a better position to move forward with the New Mexico model, where we could bring in some centralized staff to provide training and technical assistance, grant writing, fiscal management, data management, oversight, quality control. I think that's much more realistic for the branch, given our slim administrative staff.
Senator Kolb.
Thank you, Madam Co-Chair. So I must assume that it's going to come at a cheaper cost to the state of Wyoming, the unification. I'd like to hear more about that. What do you think the overall budget impact is going to be if you consider what we currently have and what you'd like to do? And of course, it must also include the unified courts with drug courts. I look forward to talking about that. Thank you, Madam Co-Chair.
Mr. Burningham, if you're ready, or Ms. Butler. Yeah.
Madam Chair, Senator Kolb, we haven't dug into the cost entirely just yet. And what I can tell you is and I think Director Johansson can speak to this better than I in terms of the staffing of what they have in Department of Health right now. But it's my understanding that they have one person, one full-time person at the Department of Health who is the treatment court coordinator for the entire state. And she gets some administrative support from the rest of his staff, but it really is one person. Frankly, I don't believe that's enough to be to really have a robust treatment court system in Wyoming. One person is insufficient. The treatment courts throughout the state are generally run by local authorities, so counties, things like that. And they do generally have their own treatment court coordinators. Some obviously are more effective than others. And I think that, that is potentially one of the things that we could try to improve with a more centralized administration staff, in that we could work with those coordinators throughout the state to really provide them with training and data management and all of those things that we think can help those treatment courts become better and more robust. I think the other thing that we would really try to focus on is having more treatment courts throughout the state. I think if I remember right, there's 16, is that right? 18, sorry, throughout the state. And in some of the smaller communities, there's not that, they don't have them. And so those avenues for some of the people who would benefit from treatment courts, they just aren't there. And so those are some of the things that I think we would focus on. As I said, we would really need to dig into the budget and figure out what that would cost, but we would hope to keep it very similar to what it is now and really try to take advantage of some of that federal grant funding as much as we possibly could. But again, I think the number of positions, both in the Department of Health and if it was moved to the Judiciary, really it's just not enough to make it as good as it could be.
Thank you, Matt, Co-Chair. That talking about this a little bit more reminds me of the Title 25 interaction with local counties, right, in the state. I really look forward to hearing how you plan on doing that, because that push-pull between, them and you, or just like me right now, it's probably the same thing in some other ways with the Department of Health. So how are you going to solve that? How are you going to work with the counties? I mean, you want to expand into counties that don't even have this program, and the ones that do, I would really like to know more about that. I realize it's probably too early in the conversation to hear that, but at a further point in time, how are you going to do that? I mean, really, how are you going to do that? And that's my ask. Thank you, Madam Co-Chair.
Representative Oakley.
Thank you, Madam Chair. Ms. Butler, you looked like you wanted to say something in response to Senator Cole before I move on.
Sure. Madam Chair, Senator Kolb, one of the advantages, I think, of treatment courts, and you heard this from Chief Justice Fox when she spoke, is that there is a lot of support out there for these courts throughout the state from the counties. The counties that we have spoken to really are supportive of them. And so I think we could really develop those cooperative relationships with those counties, both where they exist now and into the future. So absolutely, we will come up with a plan and try to present that to you at the next meeting.
Thank you, Madam Chair. And that segues. So do you have anything about success rates of these programs? And it's not necessarily even about rates, but I mean, clearly, if we're wanting to expand them, this programs where you tie substance abuse with accountability in the criminal justice system must be found to be effective.
Ms. Butler, if you know, and recognizing that Director Johansson would be next, who is actually in charge of drug courts. This might be a great question for him too, but Ms. Butler, if you know, or Judge Christensen, if you know.
Not shy of the mic. Thank you, Madam Chair. Drug courts have been studied for 30 years, coming up on 30 years. One time, and it may still be, that it's the only empirically based studied criminal justice system with amazing results. Anywhere from 75 to 85% success rate based on whatever recidivism definition you want to use at the time. But we've been studied. We used to have Dr. Carrie Heck at the University of Wyoming that studied our drug courts and did audits for us. And that was a great service that we were able to provide to our drug courts in the state. One of the things about numbers, in the past, we used to have 20s. There used to be drug courts in the 20s. We're not adding drug courts as far as I know. We're losing them. As Chief Justice Fox says, we need to revitalize and re-energize and get these out there because we're also not winning the war on drugs, but we are winning individuals one at a time who become successful, productive members of our community. And you guys meet in September and in Casper. We planning to have some graduates there for you to see and meet too. See how well their lives have changed because of their motivation in the drug court program that got them on a program to, as Judge Brown says, to pay his Social Security when he retires. So.
Thank you, Judge Christensen. Further questions? All right. With that, we'll go to Director Johansson, but obviously stay close by. We'll probably call them back up. We'll have additional questions after we hear from the Department of Health. Good afternoon, Director.
Good afternoon, Madam Chairman, Mr. Co-Chair, members of the committee. My name is Stefan Johansson. I'm the Director for the Wyoming Department of Health. Appreciate the opportunity to be with you today and talk about our court supervised treatment programs. Did prepare a brief overview and presentation for you that you should have. I won't hit all of the pages on that since there was so much good information provided by Mr. Fuller, as well as the previous speakers from the judicial branch. But if you would flip to slide number 6 on that presentation, again, just to provide some color to Mr. Fuller's overview, you can kind of see visually where we do have court supervised treatment or treatment court programs throughout the state and where we do not. Again, there's been a variation in participation in these programs at the local level or by courts across the state for a number of years. And that does go up and down over time, depending on the community and depending on the community's preferences. On slide number 7, you can see a really brief or general breakdown of our cost structure. I will say, in addition to what you see here on this table, to reiterate some of the points that were made before, our budget in the court supervised treatment program is about $6.5 million per biennium. That has gone up and down over the years as we've had to make reductions or leveraged additional funding, revenue sources, those types of things. But the funding is easy to think about $6.5 million per biennium, and generally about half and half of general fund and tobacco settlement funds that go into that program, as well as revenue that supports the program through surcharges and fees that we're able to collect and retain. You can see on slide number 7, Madam Chairman, that the program cost annually kind of hovers around that $3 million mark, with around 500 to 600 clients served in any given year. So you can see our per person cost on an annual basis, which did go down in 2021 due to some budget reductions that were made session before last. You can see our cost is typically around $4,000 to $5,000 per person. And again, that's annualized. And as was mentioned before, we do have a lot of participants that finish the program in a 12-month period, but I believe our average program completion for participants is around 18 months. Madam Chairman, on slide number 8, you can see some of that data that was just being talked about or being asked on some of our outcomes broken down by the courts that we do have. You'll notice on this slide that we track our participants by cohort. And the reason we do that is because if you don't, you essentially have inflated numbers, inflated data every time you take a snapshot of it because you have people that are still in the program. So the reason you see fiscal year 2020 data here broken down by court is because again, this is a good, about 2 years later, 18 months to 2 years later, you can get a good sense of what those outcomes might look like, whether you're looking at graduation rate, recidivism rates, et cetera. So you can see that we statewide average around 56, a little more than half in terms of our graduation rate. And that's really, really close to the national average, which is around, I think, just south of 60%, if my memory serves. Again, that's not a judgment call. When you hear something like a 56% or a 60% graduation rate, you might immediately say, well, that's not very good. That should be higher. What you'll see here in these courts is a lot of variation. There's some courts that that have really high numbers and some that are lower. And there's a variety of reasons for that, that probably run the gamut from resources, the types of participants or the types of folks that go through this program and the various conditions or social circumstances they have. But again, would just reiterate here that our outcomes on graduation rate are right around that national average.
Co-Chairman Olson.
Thank you. Director Johansson, I guess I'd like to go a little deeper into the disparity in the graduation rates. You know, understanding poor county, rich county, or rather resources in general, but when I look at Teton County at 40% and I look at Bighorn 100%, I would assume that's probably not a resource issue for our friends in Teton County. But so just understanding a little more specifically on why the rates are so variable, understanding that you're close to that national average, but obviously it's the 20s and the 30s and the 40s that are dragging your 70s down. What do you think could be different other than a magical pot of money to fix some of those counties?
Director.
Madam Chairman, Mr. Co-Chairman, it's a great question, and I'm probably not going to answer it adequately because there are so many reasons for that. But you're right. You see this wide variation, and it doesn't look like there's any sort of method to that madness of something we can correlate, to that either high performing quote unquote county or court or a low performing one. I will mention, as with everything in a lot of the data the Department of Health shares with you, our numbers are extremely low. So there's a lot of noise here when you see 100% graduation rate, with one participant that went through the program, that could be a 0% the following year. So there's a lot of, it's kind of chasing noise can take us down rabbit holes that probably won't be fruitful. But to your point, I think some of the things that are being done and have been done over the years to improve some of these rates in conjunction with the Supreme Court, in conjunction with our local courts and our community providers, et cetera, are things like standardization, training on best practices, typical grant management type efforts that you hear about frequently. I think those are the areas where you'll see better performance. And then, as Chief Justice Fox alluded to previously, I think engagement on the part of the courts, on the part of the judiciary, is a big part of that. And I'm pleased, especially recently, with some of the pushes that are being made by the Supreme Court in conjunction with our department to provide that training, to provide that standardization. But again, Co-Chairman Olson, I would just say these are tough populations to get to 100% outcomes on. You'll hear experts in this field, whether in the correction side of things or on the judicial side of things, see folks that go through these programs come back to these programs in many cases. And I've heard folks say that these are some of the best programs. If you really have a client or a detainee, someone who's committed a crime, related to substance use, that truly wants to engage and truly wants to get clean and truly wants to, change their life as opposed to, going through the correction system, that these programs are the way to do it. So I think that client engagement and that participation there is also a huge variable that I struggle to tell you exactly the best way to do that. Madam Chairman, members of the committee, I'll pause there, see if there's any questions. You can see on slide number 10, the same kind of data that I was mentioning combined for our adults and our juveniles, just in terms of some of the outcomes that we track. I will mention that the overall Department of Health reports that we provide to the legislature every year, which I'm happy to resend to this committee, does provide a more detailed breakdown on our court supervised treatment program in terms of the cost structure, the staffing, as well as not only the outcomes, but the outputs and the efficiencies, the per person cost, the amount of staffing and support staffing that goes into this program. If the consideration is where do we, where do we reside these programs? Where should these programs live? And I'll close, Madam Chairman, by saying that as I've mentioned with other Department of Health programs, I'm really agnostic on where the legislature of the state decides to put a program, so long as they perform well and perform efficiently. Having said that, I do want to be clear that I believe that with the resources that we're given to operate these programs for the past 10, 15 years or so, I think we do a good job. I think the one program manager we have does an excellent job overseeing and coordinating these programs. But a lot of what is being discussed is the expansion and using these programs more, using them for sentencing alternatives, for efficiencies in other state systems. And those are very good and noble causes that certainly the Department of Health supports. But again, as the director of the department, it's not a preference that I have of, to hold on to things and keep my bureaucracy as big as I can, but really where would you get the best outcomes? And I think the survey that Mr. Burningham presented earlier is good information on how other states structure them. What you don't see in those surveys or in those reports is how the outcomes correlate. And part of that is very challenging because the data is not uniform across states. And so I'll caution the committee on some of the data chasing going forward, that is difficult to do because different states structure these programs differently, also collect and define their data differently. But that doesn't, in my mind, make the goal of really tying program structure to program outcomes less important. And I think that should be the focus here. Madam Chairman, Department of Health is happy to support however we can over the interim period to provide more information, to provide the kind of analysis that will better inform that decision-making on your part. So with that, I'll stand for any questions.
Director, thank you. Questions for Director Johansson? Senator Kolb.
Thank you, Madam Co-Chair. Director Johansson, do you want to keep the program, or, I mean, it's an ambivalent to which way you might want to go with this, but what are your feelings? Do you want to keep it where it is, or do you want to move it to another location?
Director?
Madam Chairman, Senator Kolb, good question. And really, not to be overly frustrating, I don't have a preference. I think I understand some of the statements that have been made and don't disagree that in states where programs like this are located within the judicial branch, there probably is a more kind of vertical chain of command, for lack of a better term, where program requirements, best practices could be standardized. And I think Chief Justice made the comment earlier that judicial branch doesn't always like to listen to or take orders from the executive branch. And I certainly understand that. We deal with that from time to time in other areas as well. But if the decision is made to keep the programs in the Department of Health, and like previous speakers, I don't know the history of why that model was decided, if there was some logic to it. But if the decision were made to keep them in the department, we will obviously run it the best we can with the resources we have. If it's intended to move to another location or branch of government, we would support that as well in terms of the transition. But like has been mentioned previously, the Department of Health is one of your largest agencies, as you know, frustratingly. We have a $2 billion budget and 1,400 employees, 5 facilities. And the reason I bring that up, Senator Kolb, is because some of the items that were mentioned before, like compliance, oversight, data reporting, fiscal support, HR support, your Department of Health can do that at scale better than other agencies. And I don't say that as an opinion on this issue one way or the other. Again, we're supportive of whatever the legislature decides is the best way forward for the outcomes for these clients and these programs. But it's an important consideration, as Chief Justice Fox and Ms. Butler mentioned before. Operationally, that's something you'll want to look at. What have you historically given the Department of Health? How do we operate these programs? We have one authorized position, but many areas of my department support all of our programs, whether that's on the financial, the people side, the organizational side, contracting, compliance, et cetera. So not a great answer to your question, Senator, but again, I'm kind of walking down that tightrope and see the value in both decisions.
Director, thank you. Further questions for the director? Representative Washut?
Thank you, Madam Chair. Director, I'm looking at this a little broader. One of the things we've talked about over and over is the lack of substance abuse, mental health services in many of our rural, sparsely populated counties and areas of our state. Do you see any potential here for utilizing more treatment resources for the drug courts that could also simultaneously meet some of those needs in our rural communities through your departments?
Madam Chairman, Representative Washington, another good question. I'll answer twofold. I think, yes, I'm a wannabe economist. And so I know when there's money behind something, you typically see a market develop behind it, or maybe willing providers if you can scale in those rural areas to provide those services. So first answer is potentially, if the programs were expanded, if there were money on the table, I'm reasonably sure you'd see some entities that would organize to be able to receive that funding and provide those services. Secondly, we do struggle across the state with the provision of mental health and substance abuse resources, as we do in a lot of health and human service areas, because of Wyoming's sparse population and great distances between people. It is very difficult to scale these operations up. And the community mental health resources that we have, and that is our second largest line item in the Department of Health, you do see some overlap here, where I believe about 6 or 7 of the contracted providers for the drug courts are community mental health or substance abuse centers. So there's some good overlap and efficiency there. But that's not to say there aren't other good independent providers or other certified providers that the local community has and chooses to use in these programs. So it's a difficult answer to your question, because I do think in expanding a program like this into rural and frontier areas, or some of the counties you see on that map that don't have these programs, you will run into resource problems. How many people will go through a treatment court, and is that juice worth the squeeze for both the human outcomes, which I think everybody's supportive of, but the resources it takes to get there are, as in other areas, very difficult to scale here.
Representative Rodriguez-Williams.
Thank you, Madam Chairman. Mr. Johansson, looking at all of the programs statewide, the drug courts statewide, I'm just curious if there's any requirement every so many years to evaluate what treatment methods are being used and what resources such as learning materials that are being used. Just curious if all of the treatment centers use the same methods, or if they vary based on community needs.
Director.
Madam Chairman, Representative Rodriguez-Williams, I'm probably not the best person to answer that. I believe we have our Senior Administrator of Behavioral Health on Zoom, Matt Petrie. If we don't, I'm happy to follow up with that information. I know we have regular auditing and compliance work that we do, and resources we provide to the courts for just what you're talking about. I'm just not sure the frequency or periodicity. But if Matt Petrie is on Zoom, Madam Chairman, with your permission, would ask him to opine on that.
Absolutely. Yeah. Mr. Petrie, when you come on in, happy to hear from you.
Thank you, Madam Chair. Thank you, Madam Chair and Director Johansson. We do have standardized training for the various centers around the state. I think that, consistent with the testimony already provided, our resources there are relatively limited, but there are also best practices within the field that are followed and that are certainly advocated by the Department of Health and the Court Supervised Treatment Program here in the state of Wyoming. So we strive for as much consistency as we can possibly get in the provision of services from county to county. But quite frankly, as you can see from just the participation numbers from center to center, the resources that are available in the various programs can differ quite substantially from center to center. You can see cohorts on a slide that was previously shown by Director Johansson, where you've got cohorts of one participant versus some of the larger centers where you've got cohorts that are significantly larger.
Any additional questions, committee? Follow up? Sure.
Thank you, Madam Chairman. Just one more question for Mr. Johansson. Is there any communication that occurs between Department of Health and the judicial branch, specifically in each county, that would determine whether or not there's a need for juvenile drug courts? Director.
Madam Chairman, Representative Rodriguez Williams, short answer is yes. I don't know the details on all of the conversations that happen between our program manager and the local courts. I'm sure some of the members of Judiciary here could speak better to that than I can. But I will say, again, within the constraints that we have, I am pleased with the amount of collaboration that we do have with the Judiciary, both at the Supreme Court, the local courts, and the Department of Corrections. Frankly, I think we do what we can to make these work. In terms of expansion of juvenile programs, same answer that I gave Representative Washut. I think it depends on who you ask. There's certain folks and stakeholders that say we should expand these programs greatly. Others that, for whatever reason, believe that we should not. You will see that our juvenile programs are much lower in volume than our adult programs, and I don't really have a particular opinion or expertise on that. My personal belief is that it should be a local or a county decision on what types of programs they have for these sentencing alternatives. But it is, again, you'll get the same kind of resource constraints in rural areas where if you have one or two juveniles going through a program, is it worth having that structure? And that's probably better for the experts to answer than me.
Thank you, Madam Co-Chair. Just wanted to look at one of the sheets that were provided. It's been pointed out on the CSD program outcomes. It's page 8. Okay, it says 8. Under Sheridan Adult, there seems to be a mathematical error there.
Madam Chairman, Senator Cole, there is a typo there. That should read, I believe, 67% or 68%. It doesn't affect the statewide numbers. Those averages are fine, but that is a typo there. And we're happy to correct that for the committee and redistribute.
Thank you.
That's your number one committee right there. All right, committee, any final questions? Director, thank you. With that, we'll go to Commissioner Mom, who is with us online.
Thank you, Madam Chair and committee. I appreciate the opportunity to testify to you remotely today. And I come to speak as someone who sees firsthand the fiscal impact that these programs have on local governments and county resources. The bulk of crimes in our jurisdiction have an underlying substance use disorder or mental health component, and these programs save money. I'm also here because I know that treatment works. I'm a person in long-term recovery, and while I never had meaningful law enforcement interaction due to my alcoholism, I do know that the tools offered by these programs really can change lives of the participants and protect the community. Before I go on, I want to touch briefly on the graduation rate numbers that were brought up earlier by Chairman Olson, I believe. I think that the success rate for traditional treatment facilities like the rehab facility that I was fortunate enough to attend is 10% or less. So treatment court programs outpace national recovery rates operating within the court systems. I also would like to mention that from my research, I believe that 39 states currently house these programs in the judicial branch. So it's much more prevalent in that, as earlier testimony reflected. I believe that moving the program opens the doors for expansion and greater criminal justice reform. There are at least 11 other diversion court programs operated in other jurisdictions that could lessen the burden on our court system across Wyoming and lessen the burden on our jails and institutions. To respond a bit to Chairman Olson's earlier comments, I believe inconsistencies in programs and outcomes statewide have as much to do with the buy-in of the judiciary, which is the majority of the treatment team involved in making the programs work, as the lack of substance use disorder treatment options in local communities. While I know that all the lawyers on this committee are the embodiment of altruism, having the Supreme Court leading on this program may better incentivize, legitimize, and encourage participation by other members of the legal community. And so I just strongly encourage the committee to make this move and help us expand and protect our treatment court programs throughout the state. And I'm happy to answer any questions.
Always wonderful to have you, Commissioner Mom. Questions for the commissioner? Representative Provenza.
Thank you, Madam Chairwoman. You mentioned the reduced costs for counties. I'm wondering if maybe you've been able to find some, if you have any numbers that relate to that. I'd be curious how much of a savings you have, or if it's just kind of anecdotally.
So anecdotally, and I can get you harder numbers from our treatment court coordinator, or potentially Mr. Volk from Natrona County will have that number, but I believe it's for every dollar spent on a treatment court is a savings of potentially $4 in the jails and in the court system. So 4-to-1 savings.
Thank you, Commissioner. Appreciate having you here today. With that, we'll go to Mr. Volk, Program Coordinator for Natrona County Adult Drug Court.
Hello, thank you very much for having me in today. This is my first time speaking in front of this committee, and I'm just honored by it. I also want to just give a quick congratulations and nod, I guess, to Mr. Malm, Commissioner Malm. Thank you for your bravery in sharing your story with us. So I don't have any hard numbers so far as the cost effectiveness of drug court. That is something that I plan on digging into, at least in Natrona County nonetheless, as those questions keep coming up, and the numbers I'm sure are different. The cost I'm sure is different from county to county. I can tell you that anecdotally speaking, this is far more of a cost-effective program, and I'll just piggyback on what Mr. Malm mentioned. Traditional treatment is not nearly as effective with the criminal justice population as drug courts are, just because we know that the longer an individual is in treatment, the better their success rates are going to be maintaining long-term recovery. Traditional treatment is very much governed by insurance and people's funding sources, whereas the drug courts have arranged this to where it's a very nominal fee for a client to participate in the program for at least a year. And in Natrona County, in all actuality, our program is 18 months long, and it only costs our participants $1,100 for the entire program. Whereas in traditional treatment, that might get you a day in a residential facility. But what I really wanted to speak to, and it does apply to the subject at hand, is from my perspective, drug courts are where the health services meet the legal system. Because addiction is a healthcare issue, but it impacts our legal system. It's a healthcare problem that leads to breaking the law. But what makes drug courts so successful is that the law stays involved at a high frequency for at least a year. And that any of our graduates will tell you that it's the intensity of the supervision that has allowed them to really gain from the treatment. So personally, I don't really have a dog in the fight when it comes to which department drug court is under, with the exception of I hold Judge Christensen in the highest regard. He has been here since the inception, and if he feels that it being under the judiciary system would serve us better, then I'm all behind him on that. Something else that I wanted to also mention is you guys all got to look at that chart of success rates, and I want to echo the concern of standardization. I think a large, dare I say, error in that data is it's coming out of our new case management system. I put that in air quotes because we are already looking for a new one. You could talk to the state program coordinator. I believe that's her title anyway. I'm referring to Alicia Johnson. She's putting out an RFP to create our own case management system where all of the programs could be much more standardized. The number that Natrona County has is actually very insulting because it's just very wrong. I hate to put it that way, but I was privy to that report a few months ago and took the liberty of just looking at all of our numbers at the raw data. The past 3 years, Natrona County has actually had a 72% success rate. So our graduates from the last 3 years, 72% of them have not had any interaction with the legal system at all. No one, I mean, can brag about that kind of number. And I use that number, I use that word brag deliberately because that number is huge. Success rates is about 10% in traditional treatment. Large part of that is you're focused on, as a treatment provider, because I'm the coordinator here at Drug Court, but I've been working as a drug and alcohol therapist since 2005. So I can speak to, in treatment, a huge part of the therapist's job is to help our clients turn their extrinsic motivation into intrinsic motivation. We want them to have that motivation inside. We need them to have it for their own selves. But the way I put it is they need to have the nudge from the judge to get them into the treatment program in the first place. Drug court keeps them in there long enough to where we can really mold that motivation for treatment. Furthermore, I wanted to just briefly discuss how we are looking at retention rates. Natrona County, in the last fiscal year, so up to this date, we have a 25% termination rate, which means our retention rate is 75%, which is still very good. But of the 25% of our clients that we've had to terminate, 70% of those people actually just absconded on their own. There were only 30% that I consider were truly terminated because of their non-compliance with the rules. Within that too, I'll briefly discuss our in-program recidivism. We, as of this year, have a 7% in-program recidivism. 7% is nothing, and it's still within the grant's stipulations. We have to maintain under 12. But I'll also mention that the hard number of that 7% is 6 people. We've had 6 people who have reoffended while they were in program, 2 of which we kept in our program, and they're now pretty successful within the program itself. So, I realize that funding is always a concern, and there was also a concern about how we've lost drug courts in the state of Wyoming. Anecdotally speaking, and I spoke just to a couple of our other coordinators, and one reason why we lost some of the drug courts, I'm not going to say all or a majority of them, but when we were required to become a CARF accredited agency is what led to some of these counties giving up drug court. Drug court is just a small piece of what CARF, the accreditation agency, looks at. And so when we have to become CARF accredited, we have to abide by many rules and regulations that really don't apply to court supervised treatment. And so these smaller counties said it wasn't worth their time and energy. So let's see here. As I mentioned too, funding is also always going to be a problem, and I understand that. Other coordinators have reached out to see if they could start billing third-party payer sources such as insurance companies, but they've run into various issues. Either they weren't a nonprofit, or because they were a governmental agency, they weren't allowed to bill. So there's always issues there. And so if coming under the judicial wing, if that does offer more opportunity for various funding, I think it's vital for us. I have a staff of 4 people that are in my payroll, and we just are gracious. We're just have a wonderful community of people to work with. That probation and parole share 2 of their staff, and Casper Police Department shares 1 of theirs, to where we have a full staff here. So only 4 of our staff are in my payroll, but to be able to give them financial incentive, which really that's what we all are here for in one way or another. My question always is, would you do it if you weren't getting paid? But makes it really hard to give pay raises to staff when we're on a very limited fixed income. So any opportunity to have more funding would be huge and largely beneficial. Because our client participant fees is not guaranteed funding. And I mean, even though it's part of our rules and regulations, we're at the whim of our clients being able to, see us as something that is a valued thing for them to pay every month. And then also our surcharges go to the whole state, whereas conservatively speaking, I think if money came out of Natrona County for drug court operations, it should stay in Natrona County, as opposed to having to apply for it every year to get the money that was generated from our county back into our county. Oh, one last thing I wanted to mention. Thank you very much for giving me
Promise it's the last, Mr. Volk?
I'm
You've
sorry?
said this before. Do you promise it's the last?
I think so.
We'll keep you close by though for questions from the committee, okay?
Okay.
So go ahead and wrap up. This last
Well, I
thought.
just have this one last thought. It would be great if the voluntary status of juveniles could be taken off the statutes. Because right now, the way it reads is a parent has to voluntarily allow their child to come into a juvenile court system or a court treatment system. And if that was not on the statute, we would have way better of an opportunity to work with adolescents. Natrona County does have a student court program, but it's not under the CST. The student court program functions under the whole premise of student court is to graduate high school. And then treatment is a part of that. It's a great model, and I think it could be incorporated, and we would just have a much better turnout, I believe, if the participants didn't have to, voluntarily come into a drug court. So student court is a completely different thing, but I believe if it wasn't voluntary for juveniles, it would be much more accessible. So now I will pause for questions.
Mr. Volk, thank you. Questions for Mr. Volk? Representative Craigo.
Thank you, Madam Chairman. Just a quick question, Mr. Volk, for sort of background for all of us. In Natrona County, how exactly does your budget break down? And I don't need exact numbers, but what portion of your money is provided by the county? What portion is provided by the state, outside grant funding, et cetera? If you could just give us a snapshot of that, that'd be awesome.
That's actually a pretty easy question to answer. We get no funding from any other source other than the grant. The county has made it pretty clear to me that they're not going to give us money, but they give us in-kind services, which the grant says it's either match funding or in-kind services. And so we get some administrative help from the county. That's just an in-kind service. So we don't actually get any funds.
All right, thank you. With that, we're going to go back to Justice Fox, who's joined us again, who might be able to answer more thoughtfully, more deeply, the cost benefit analysis associated with that. So Justice Fox, if you could go ahead and start, the floor is yours.
Thank you, Madam Chair. I do have some information on the cost benefit. The Department of Health had the University of Wyoming do a report pretty recently, the end of last year, on the cost benefit of court supervised treatment programs, which I'll just provide the whole report to Mr. Fuller. Is that the best thing to do?
That is wonderful, Justice Fox. Yes, or if you just want to do a quick summation of the results, that'd be great.
Okay, so the summary of key findings says the state will save almost $900,000 per cohort in 1 year following graduation. 3 years following graduation, the savings would be more than $5 million per cohort, and then 5 years after, $10 million per cohort. And that, to back up, would be in 1 year following graduation would be $1,800 per person in savings to the state. In 3 years after graduation, $10,000 per person savings. And then they say by investing in the court supervised treatment programs, data show after 1 year, the state will save an estimated $41,500 just in prevented arrests. So as I said, I'll give you this whole report and you can have the details, but just the summary tells you the cost benefit of treatment courts. Thank you.
Thank you, Justice Fox. Appreciate that additional information. Questions from the committee about that report? Representative Provenza?
Thank you, Madam Chairwoman. Justice Fox, I'm wondering if you can just elaborate a little bit on that saving. So is that coming from our savings from, say, having someone then enter Department of Corrections if they did recidivate versus in terms of recidivism, sorry, words are hard right now. Just trying to understand more about that on the numbers level of what that cost savings is. Is that strictly Department of Corrections or saving that there?
Madam Chairman, Representative Provenza, I do think that this is this summary relates to the cost of incarceration. That's what those comparisons are. I'm not 100% sure if this report goes into other kinds of cost savings that we see. For example, if the participant isn't incarcerated, can keep his job, can not have his children taken into DFS custody. Those are sort of secondary savings that I think are hard to quantify, and they may exist in this report, but I don't think so.
All right, thank you. Final questions for Justice Fox? All right, thank you all for being here. I know that we have additional public comment here in the room. If you could raise your hand if you're interested in providing public comment on this topic. All right, Director Shannon, looks like we've got 3 or 4 more. The time is 3:25. Just announcing that for our agenda, we'd hope to be done with this topic by 3:30, and we have another item under this topic to address. So we're pushing for time. So I'll start pushing you for time as well. So please don't be upset if I have to shorten up testimony a little bit in light of that consideration for our committee members who need to travel home some pretty long distances. So with that, Director Shannon, please come forward.
Madam Chair, committee members, I'm Dan Shannon with the Department of Corrections. I'll just make some brief remarks with your permission on some of the comments and testimony that was presented today. I just would, though the Department of Corrections is not the end user of our specialty courts, our correctional facilities would be overrun without it's very clear. We contribute 17 pro agents to the specialty courts. And I'd like to address just a few comments. One was from Senator Kolb, Commissioner Malm, as well as Representative Renzo. If you look at the cost of the data was presented today at $6,200 per inmate. We're housing our inmates at $44,000 per year. And you look at the 300 graduates, the Department of Corrections would be overwhelmed, and the cost, the direct cost from our general funds would be astounding without these specialty courts. We certainly, the being the Department of Corrections, certainly respect the judges and support they being the leaders of these courts. Justice Fox comment about executive branch and judiciary. I kind of felt that I was maybe the poster child of that a while ago, and I'll tell you my reasons why. Department of Corrections, our supervision models was being studied, and we changed it to risk recidivate instead of community risk. And with that, I heard from a lot of judges saying this is not really fitting in with our models of specialty court. A couple other things that I would like to comment. We recognize, and I think it was Representative Washington or Representative Rodriguez Williams speak about the necessary of treatment. With all the cuts in the Department of Corrections taken over this past year, we never cut no treatment. That was one thing that I held tight upon. So with that being said, I'm really proud and glad to see the uniformity within the act, if all possible, and we would support anything that would benefit this. We being a Department of Corrections would support anything that would help improve the specialty courts of our state. Thank you, Mr. Chairman.
Director Shannon, thank you so much. Questions for the director? All right, seeing none. Thank you. Ms. Somerville. Welcome, Ms. Somerville. If you'd introduce yourself to the committee.
Thank you, Madam Chairman. Andy Somerville. I'm the Executive Director for WAMSAC, Wyoming Association of Mental Health and Substance Abuse Centers. And I promise, Mr. Chairman, due to time, my comments will be very brief. I am here today, just want to talk from the perspective of 7 out of the 13 counties. The current drug treatment court programs are run by community mental health centers. And I wanted to comment on Representative Washett's question earlier about the rural areas. We are currently operating them primarily in the smallest areas: Bighorn, Johnson, Lincoln, Teton, Uinta, and then Sweetwater, which is our largest county. So we are already there, are already there trying to provide those service and economize those scales because there's not additional options in those counties. We are very supportive of drug court treatment programs. Obviously, I don't think I need to tell the committee about that at all. We're also very supportive of all of the efforts with the criminal justice system. But I want to just remind the committee, we're several years into the state legislature issuing a number of criminal justice reforms that touch on mental health and substance abuse. House Bill 31, which was designed to create a tighter relationship between the community mental health centers and parolees are coming out of the DOC system. That is several years old. It is in the works, but it is also severely short of funding. It should be 3 full-time employees. It currently only has 1. It does not have the funding to provide the training or the necessary pieces that were designed to go into that bill yet to make that effective. We are still working on it, but it's ongoing. House Bill 38 from 2021, that is the behavioral health reform bill. In that bill, 2 of the tier 1 priorities are state level criminal justice and non-state level criminal justice. Again, that's a bill directed at the community mental health centers and the services that we provide. That reform process is currently ongoing and will become effective July 1, 2024. But as was alluded to by Director Johansson, there is significant overlap. It's certainly the direction we've taken from the state legislature is that the community mental health center needs to get more involved with criminal justice or justice involved clients. That's not a new population for us. We've concentrated on it before, but we've certainly gotten the message to double down. But we have a lot of initiatives going. There's a lot of pieces that I would be happy to send some information to you guys after the committee to just kind of save time. But I think I want to leave the committee with the thought of there's a continuum of care. Some comments were made about residential treatment. That is different than drug court treatment. And just to make sure I'm on the record, the current successful graduation rate for residential SUD treatment at our facilities is 83%. It does work, but it's a different type of treatment than drug court, which is outpatient or intensive outpatient. But they're all important pieces to the system. Our only concern in terms of this conversation about where it's housed, and I think we're fairly agnostic as long as we want to encourage support for our judicial partners, our DOC partners, et cetera, is to make sure that we maintain excellent clinical quality expectations of the clinicians that are providing the drug court treatment. There's nothing worse than having a clinician that is not properly trained in dealing with criminal justice or particular substance abuse issues and then providing treatment, because that reduces the effectiveness and has a big impact on that person's life. So no matter how we do that, we think that that's incredibly important to make sure that your clinicians, whoever that is, and it varies. Some of the counties use internal, some of them use private providers, some of them use community mental health centers, that they are using evidence-based practices and that they are well managed. And the only question that I have so far in the process is, how would that look under the administration of the Supreme Court? So with that, I stand for any questions and look forward to further conversation.
Ms. Somerville, thank you so much. Questions for Ms. Somerville? All right, seeing none. Who's ever, Ms. Forslund? Yeah, please come forward. And then raise your hand if you're interested still and kind of get in the wings to come forward. Great.
Thank you, Madam Chair, Co-Chair, members of the committee. I'm Cheryl Folland, legislative advocate for the Wyoming Association of Addictions Professionals. We obviously aren't torn one way or another where this is housed. However, we do concur with Ms. Somerville that we have the best trained people possible. We do work a lot. I am in private practice. CARF certification doesn't mean it's the end all save all and everybody's going to be wonderful. We're asking for some reasonable accreditation standards or certification standards for private providers who do not have the support systems in place administratively for CARF certification. It is extremely expensive. It is extremely time consuming. The majority of our private providers are one-person shop. We're the billing department, we're the janitorial service, and we're the clinician. So what we're asking for is reasonable expectations, reasonable certification standards. And we would also obviously love to work with whoever wants to put that together. I was very fortunate early in my career as a probation officer in Houston, being able to work with the specialty courts, including the first drug court in Houston, the first mental health court, and the first veterans court. So I'm very pleased and encouraged that this committee is looking at what possibilities we have. There is a cost savings to the taxpayer. There's also savings to the families. There are savings to the employers. Employers want people that can come to work. We're already short-staffed. In the labor shortage that we have right now, employers need people on the ground in place and hopefully not using. So employers are willing to work with the courts as well. We want everybody to be able to be successfully completed. Not every criminal justice person is going to be appropriate for the program, and the National Institute does in fact have those standards already in place. And I think the team that has been doing this for so long, and I commend Judge Christensen, he probably doesn't remember me, but that's okay, when I lived in Casper. His team is phenomenal, and we would like to just see progress going forward, not going backwards. Thank you, Madam Chair.
Representative Washington.
Thank you, Madam Chair. Are you aware of a reputable accrediting body that focuses on single member organizations, single provider type organizations? Are you aware of one?
Ms. Bowen.
Madam Chair, Representative Washington, at this point in time, the only credentialing that's available would be through the National Association of Addictions Professionals, the NADAC Center, which credentials providers and substance abuse. As far as I know, the other professional organizations do not have specialty certifications, but it's also something that we would be very happy to have conversations with the committee and our peers in putting together.
All right, thank you so much.
Thank you, Madam Chair.
Mr. Craig, yeah, please come forward. And again, right now, the committee is considering transferring the current operations of the drug courts, the treatment courts, into the Supreme Court. So there's no proposed elimination of treatment courts on the table or even remotely being considered. So I just want to make sure that that's clear and understood, and help kind of guide some testimony. Mr. Craig, welcome.
Thank you, Madam Chair, members of the committee. My name is Frank Craig. I'm the state director for the Gateway Foundation. We're a nonprofit organization that contracts to the Wyoming Department of Corrections and provides substance use services. I'm also the president of the Wyoming Association of Addiction Professionals. I just wanted to make a quick comment about the course that I have seen Wyoming going in the past probably 5 or 6 years, addressing a special population, which is criminal justice. And it's a fantastic course that we're on. We have a lot of work to do as well. I just wanted to speak to the fact that when we're talking about substance use disorder, we're talking about a very primary, progressive, and even fatal disease. And in dealing with a special population, the criminal justice system, as the treatment goes, we have a broad continuum of care. And I don't want to see us get bogged up in compartmentalizing where each part plays in that continuum, if that makes sense. If we have, in a drug court sense, kind of an introduction when people are coming into the system to be identified and assessed at a particular level, and making sure that at that point in time that these individuals are getting the proper dosage of treatment. Just like with any other disease, and matching that dosage based on what that individual's needs are, but then following and progressing that throughout the possible and likely rest of their criminal justice career, including institutionalized treatment, and then making sure that we're connecting in an aftercare program the proper support for those individuals to continue that recovery lifestyle. When we talk about addiction, just in general, it is plagued by people that relapse. And it's just something that needs to be understood when we're talking about treatment, in the sense that did the treatment fail? Did the person fail at treatment? Or is this just part of their disease, the way that it progresses? And allowing opportunities, again, to address that dosage that's needed at any point in time in that continuum, based on the resources that are available, which are not very many in Wyoming. And with that, I would stand for any questions.
Mr. Craig, thank you. Questions for Mr. Craig? Look forward to working with you through the interim. Director Schmidt, welcome.
Thank you, Madam Chairwoman. I come to you as a former drug court coordinator and not necessarily as the director of the Department of Family Services. So I was the treatment court coordinator for a abuse and neglect court in Billings, Montana. And so the conversation about where does this best sit in terms of the Supreme Court versus the executive branch. I was also at the Mental Health and Substance Abuse Division when the court supervised treatment program was undergoing a lot of question and then was placed at the Department of Health. So from my experience, I found that as a drug treatment coordinator, having the program under the auspices of the Supreme Court was a little bit more comfortable because you had judges talking to judges. You had the Supreme Court justices understanding what the role of the courts were, and then the rest of us could fall in line according to our roles. As the director of the Department of Family Services, I also think that having it at the Supreme Court would be beneficial to us, as I do think it gives us some opportunities for conversations to talk about what's the role of juvenile court in terms of treatment courts, and what's the role of There was a conversation about juveniles, what juvenile delinquents, what that role is, and certainly juvenile court is a place for those discussions as well. So I'm, really I'm indifferent to the policy decision, but from my experience, I think that there's been some benefit to locating them within the Supreme Court.
Thank you, Director. Representative Provenza.
Thank you, Madam Chairwoman. Thank you, Director. I'm wondering if you have any comment on, we talked about the voluntariness of having parents and being able to place youth under the drug or the treatment court. Do you have any experience with that, or like what are your thoughts on that, I guess?
Madam Chairwoman, Representative Provenza, there's been conversations about pre-adjudication and post-adjudication drug courts. So do you offer up drug courts as a way to say, if you like a diversion program, compared to after there's been a finding, and then it's kind of a way of maybe benefiting more from the services? And I don't necessarily have an opinion, but I do think as we look at the department is looking at community juvenile service boards and diversion programs, certainly having a pre-adjudication model would be beneficial in regard to that programming. But, even with that, I would expect that there has to be some level of parental permission.
Representative Rodriguez-Williams.
Thank you, Madam Chairman. Ma'am, if the switch were made and we transferred drug courts over to the judicial branch, do you think, well, it was said that funding opportunities there'll be further funding opportunities if the switch were made. Do you think it would be feasible to streamline drug court and juvenile drug courts statewide so that people that live in areas where there's not currently a drug court could take advantage, like regionally, to a local drug court, if that makes sense?
Director.
Madam Chairwoman, Representative Rodriguez-Williams. So streamlining and cost savings is interesting because you're going to hear me talk about how I think the program's probably underfunded as it is. One of the benefits of having this approach is that you really are buying treatment, and a very specific treatment for a very specific population. And so when you start to blend those populations in with other services, then you kind of lose, I think, the focus on what that's about, that treatment court and the judicial presence and all of the attorneys and the interested parties being able to really talk about the best way for that client and client himself or herself to move forward. So I don't know if there's necessarily any cost savings, but certainly there may be more opportunity to look at the role of the judges in those drug courts and how are those responsibilities shared. County attorneys or prosecuting attorneys that are also involved. And then certainly from a DFS perspective, if any of those were juvenile court related, then yes, there would be opportunity to use a lot of the things we already do in juvenile court, processes that are already there that somewhat mirror what a treatment court does. And that's the multidisciplinary team.
Thank you, Director. Any additional questions, Senator Kolb?
Thank you, Madam Co-Chair. On the grants writing question, who would be writing those grants? Do you have a specific person that would be in charge of that? Or what would that look like? Thank you.
I think that's to Ms. Butler. Ms. Butler, if you can.
Madam Chairwoman, Senator Kolb, I think this goes to my point that treatment courts as they sit right now are understaffed. We would likely need a grant writer. We don't have one currently within the judiciary. What I can tell you is we do have an administrative staff, right? So I actually supervise them. So we have a legal team, we have an HR, we have a fiscal team, we have those pieces. You will always hear me say that we can use more of those people to do those jobs. But there are some pieces that we would definitely need to fill in if this was to be transitioned to the judiciary, and grant writing would be a big piece of that. We would like to be very aggressive about going after federal grants that are available for treatment courts. And to do that, we need a dedicated person that can spend the time to really make sure that we can go after those and hopefully be successful in getting them.
follow up? Thank you, Madam Co-Chair. Does the Department of Health currently write grants for this purpose? I mean, it sounds like an opportunity that we could do better with for doing more grants writing. So is that saying then that the Department of Health is not writing these grants that we could be using, or it's unique to the judiciary and they'd be able to write different grants?
Ms.
Thank you.
Butler, if you know.
Madam Chairwoman, I don't, and Senator Kolb, I don't want to speak on behalf of the Department of Health. I think Director Johansson is probably better suited to answer the question about how aggressive they are with federal grants in their department, specific to treatment courts. I think in our circumstances, what we would have is we would be looking at having a grant writer that would primarily be geared toward writing grants or writing grant proposals for the treatment courts. And I think they probably potentially have grant writers, although I'm seeing a nod. But as you heard Director Johansson say, they are a big agency. We are much smaller. We don't have one. And if we did get a grant writer, it would be geared primarily towards getting grants for treatment courts.
Representative Washut.
Thank you, Madam Chair. Just briefly, would the grant writer also be involved in grant compliance documentation? That tends to be a very time-consuming component. We always talk about getting the grant, but then somebody has to do the administrative work of documenting compliance. How would you foresee that happening within the judiciary?
Ms. Butler.
Madam Chairwoman, Representative Washut, yeah, I believe that's correct. The grant writer would be the grant writer and the compliance manager and have support from our staff.
Representative Zwanitzer.
Thanks. Slightly tangential. How many other large-scale programs at the $3 million level does the Supreme Court oversee outside of independent judicial districts? Judicial learning? I'm trying to think, do you have any other statewide level, I would normally call them executive type programs, but anything comparable that you currently have now in the Supreme Court in its programming funds?
Ms. Butler.
Madam Chairwoman, Representative Zwanitzer, so the judicial branch doesn't generally have programs. We have people and we have cases. We do have one of the programs that I would think is somewhat similar to a treatment court program would be our Children's Justice Project. And so we have a Children's Justice Project coordinator and we have a Children's Justice Project director, and they are federally funded primarily. And what that program does is it really works to try to get kids who are in the system because of allegations of abuse and neglect through the system quickly and have better outcomes for those children. So that I think is one program that would be similar to this treatment court program that we would be looking at taking on if that was the decision of this committee and the legislature.
Representative Provenza.
Thank you, Madam Chairwoman. And maybe this question is better answered by Mr. Burningham, but my understanding with the grants is that, is that maybe they're directed towards specific programs. So correct me if I'm wrong in that. So a grant might be written and it has the requirement that the entity that applies for it is a Department of Corrections or under some certain jurisdiction that maybe we're not fitting into. Am I misunderstanding that?
Chairman Nethercott, Representative Provenza. So there are a wide range of grants available for treatment courts. There are adult treatment court grants, juvenile treatment court grants, mostly administered through the Department of Justice. And in looking at those grants, we've seen nothing that would somehow disqualify the Supreme Court if we were to have full administrative control over treatment courts. And as we mentioned earlier, New Mexico and Montana, 2 states where the state Supreme Courts have primary control over treatment courts. These states rely heavily on these federal grants. I know that it's the Supreme Court that applies for, administers, and ensures compliance with their grants.
Representative Zwanitzer.
Thanks, Chairman Nethercott. So I'm still missing it. These grants arguably are not specific to the judicial branch. If the Department of Health wanted to go after them, they're certainly in their purview to do so at this time. So that's my first question. I already threw one hardball to Ms. Butler today, but my second question then, have you heard complaints from judges or from around Wyoming that the Department of Health is not going after these funds and your treatment court judges wish they were doing more in this regard? Is that where it's stemming from? I'm missing the why. Yeah, if you could help me with that.
Why, Mr.
Chairman Nethercott, Representative. So that these, my understanding is that Department of Health could pursue these grants. And my understanding is that in the past, they have not pursued statewide grants, that the policy has been that individual treatment courts should apply for these grants if they want supplemental funding. Now, I certainly defer to Director Johansson. He has a better grasp on what the department is doing and what their policy is towards pursuing grants. I'll just say that at the judicial branch, we have, and speaking to other states, recognize that there's a potential for the state to get its hands on these millions of dollars to make our treatment courts more robust.
All right, any additional questions? All right, any additional public comment? Director Johansson, please come forward.
Thank you, Madam Chairman. Very, very briefly, I just want to make it clear that there's not a federal pot of money that we are choosing not to go after just because we don't want it. Their federal grants come with federal strings, and the reasons why the department has, in some cases in this program, not pursued federal grants is because there are requirements that either we cannot meet or we don't think are feasible within the capacity or resources we have. There are things like, and I'm not speaking about grants that are currently available. I have not looked at what's out there right now, but in my experience and history with the department, sometimes there are state matches that come with those grants, and we are in a budget period where we've been told not to ask for general funds, or the providers need to have an additional local match, and we've determined that's not available, or capacity issues within the department. Again, federal grants come with federal strings, reporting requirements, those types of things where sometimes we have to say no to federal funds that are available. But that's not to say that we wouldn't support expanding, funding that would support these types of programs. We do have and do receive a lot of grant funding from the federal government throughout the Department of Health. So just wanted to make that clear, but I'm happy to get with my staff and look at the grants that are currently available. And if there's a feasible one that we're not going for, and there's not a good reason why, I'm more than happy to provide that information to the committee and change course.
Representative Swanitzer.
Thanks, Benjamin. So I'm sorry to put you in a tough spot, but has the court, either the judicial branch or any of the treatment courts, reached out to the Department of Health and said, hey, we have some grants here we think you should go after. Would you look at pursuing these? And you've said, we don't think this is good right now, or is this kind of coming out of the blue for you all of a sudden? Everyone's saying there's all these grant funds if you wanted to go after them. My question is, are you aware they're out there? You've been asked, and the decision has been not a good time with the current budget environment.
Madam Chairman, Representative Swanitzer, the answer is yes, that I know the judicial branch and the courts reach out frequently on things that might be funds that might be available, opportunities, grants or otherwise that might be available. I can't speak to the specifics. I just don't have that information in front of me on what's been proposed recently, but again, happy to do that legwork.
All right. Further public comment? Yes, please come forward. Welcome to the Joint Judiciary Committee. If you would introduce yourself to the committee and please share your thoughts.
Oh, there we go. Now I can hear myself. My name is Sunny Goggles Duran, and I'm the current director for White Buffalo Recovery Center, but I was previously the director for the Shoshone and Arapaho Tribal Drug Court from 2005 all in Dwelly until 2014. One of the things that I wanted to ask the question about was specifically We had gotten state funding for several years. We currently do not have a state contract, but the process was always through the Department of Health through a contract. I'm not sure if the Supreme Court has had experience with working with the tribes as far as developing those contracts, and how would that process work?
Great question. Ms. Butler?
Madam Chairwoman, so I can't tell you the specifics of how that would work right now. One of the things that I can tell you is the collaboration, I think, between the Department of Health, the Department of Corrections, and the Judiciary would still need to move forward for these treatment courts to be effective and work. You know, there's expertise in the Department of Health that we don't have in the Judiciary. And I think we've talked with Director Johansson about some of the difficulties that I think we will need to overcome. And that really is going to be figuring out those relationships and that collaboration and what that model looks like. Obviously, the Department of Health has the expertise in working with providers. And we would like to, if they are amenable, pull on that expertise and to help us prop up the program. The same with the Department of Corrections. They have been a wonderful partner for treatment courts, and I would hope that that collaboration could continue. So I can't tell you specifics, but what I can tell you is we would fully expect and hope that we can continue the collaboration with those executive branch agencies to ensure that those treatment courts are effective throughout the state.
Any additional questions, committee? Right, any additional comments?
One last comment, Madam Chairman. I'd also like to, really emphasize the effectiveness of treatment courts. I've worked with treatment courts for several years. I've actually contracted with several tribes to help them develop their treatment courts. And there are several models. I like the comments that were made specifically about the judges and having them on board. I really, really do believe that the judges have the most influence when it comes to those treatment courts. But at the same time, you want effective treatment. You want providers that have that experience, and you want a way to regulate that. I've worked in the substance abuse field for the last 18 years. Some providers are not meant to work with people that are in the criminal justice system. Some providers don't do well with adolescents. So having some type of authority or some way to regulate that is definitely necessary. And I can tell you that because I've worked with some really good providers on paper that were not very effective with the clients when it came down to it. So just wanted to add that.
Thank you very much. Any questions from the committee? All right, appreciate you being here. Further public comment? Anyone else online? All right, public comment is closed. Committee, back to you. Senator Cost.
Thank you, Madam Chair. I would move that we formulate a bill which would create the process for transferring from public health or from the Department of Health to the judicial system, the movement of the drug courts. I think that we've heard enough testimony and we've seen the number of states that are involved with it to where that seems to be the most supportive area. That doesn't mean that we don't appreciate Department of Health or the others that are involved, but if there's a way that we can continue these and hopefully grow them, having been involved with the one in Cody and witnessing it, they're unbelievable in what they do. And I think we've got to make sure that we can continue to try to get these people into the productive part of our society.
Thank you, Senator Cost. Is there a second? Seconded by Senator Cooper. Discussion. Senator Kolb.
Thank you, Madam Co-Chair. I just like to be clear to everyone here that while I was a county commissioner, drug court was probably the most effective group of people dealing with folks in the justice system that had issues. They were far more effective than I don't know whether really programs in our county it was really made a bigger impact with the amount of money and manpower. We only had one person as a director working with the courts, but it was a very, very good system. Out of all the ones that I was ever exposed to, I have nothing but admiration to what they do and how they do it and the success they had. Now, I still would like to know the why. Okay, I heard a lot of reasons why. I mean, superficial reasons, but really at the core of it, what's the why? I mean, I think I haven't heard a good answer. So I look forward to hearing that. I'm in favor of the discussion. Thank you, Madam Co-Chair, for my chance to make a statement.
All right, further discussion? Representative Swanitzer?
Thanks, Madam Chairman. I think the why is because we all agree they work, and it looks like we have an issue where we'll call it a branch of government believes that there's more money that can do more good if we pursue those and versus status quo. But then I also heard that the judicial branch would probably need a grant writer to engage and maybe another position or two for coordination, right? Let's say up to 2 positions, arguably. We could also give 2 positions to the Department of Health and mandate that they spend a little more time and energy promoting, this area and going after some grants. And I don't know how you do that statutorily, but it does sound like I have one branch of government that's very gung-ho and wants to pursue this. I just have difficulty saying, let's move what in my mind is an executive branch program into the judicial branch. I know other states do it, but there have been some other things over the past 15 years where we could have moved them into the judicial branch. The GAL program we heard from yesterday, I think would probably personally operate better as a segment of the judicial branch, but the legislature has historically resisted putting anything that was an executive branch function under the judicial branch. So my concern is we move it, that's great. And for right now, there's a lot of energy behind it. And 2 or 3 years from now, we've given the judicial branch more positions, and that energy, goes away. And I just am not sure we need to restructure government to do that. And so my question ultimately is it better to add another position to the Department of Health or increase that level of responsibility if they have in-house expertise in grant writing and put the push more as a budget footnote directive to go after these things for a year and see if they are available? I struggle saying let's move an entire program to a different branch of government when I think the problem is we aren't supporting at the level we need to be right now, if that's the legislature's intent to really push this forward, which I think it is.
Representative Rodriguez-Williams?
Thank you, Madam Chairman. Just further discussion. I too have similar concerns. How much will government grow as a result of this transition? How much disruption it would cause? And would the counties continue to provide in-kind services such as office space like they're currently doing? Just several unanswered questions still.
Senator Cooper?
Thank you, Madam Chair. I see this as an opportunity to expand this program across the counties that are underserved right now, across the eastern part of the state and up in the central part of the Bighorn Basin. I think that as a focused program under Judiciary, we could probably do a lot better job of serving the whole state. My observation. Thank you.
Further discussion? Representative Craigo?
Thank you, Madam Chairman. So I have some of the same issues that some of the former speakers have already mentioned, cost, et cetera. But I guess I'm going to ask that we go ahead and move forward with the bill draft, continue this conversation at our next meeting, and maybe get some more facts, get some more, more specifics and exactly what's this going to look like if we go ahead and do this. Get a better idea from the judicial branch exactly what they're thinking and what's the cost associated with that. And on the flip side of that, what kind of money do they think we can go after? I mean, give us some actual numbers, where does that stand and how's the cost benefit going to break out for our participants in our counties across the state? Thank you, Madam Chairman.
Further discussion? Representative Washit?
Thank you, Madam Chair. I guess I'm not sold one way or the other on this at this point, but I think most of the time we do a bill draft and we bring the thing forward, and sometime before the session, we get a fiscal note to go along with that. I think this might be a case where we need the fiscal note a little earlier in the process before this committee puts its imprimatur on the bill.
Representative Provenza?
Thank you, Madam Chairwoman. Yeah, I guess I would just urge the committee to move this forward because I do think this is going to be complicated in that we want to be able to look at a bill draft, work it. I just worry about coming to the third meeting with a bill draft and it needing more work done than we can maybe do while we also get those answers. And I think, you know, in terms of the fiscal note, I mean, I think it's going to be difficult to understand, you know, we're going to know how much it costs to put people in, but those positions are going to hopefully and probably be paid for multiple times over by the grants that they then would provide. So I would urge the committee to kind of support just moving this a little bit more just because of the complicated nature.
Senator Cole.
Thank you, Madam Co-Chair. And on the grants issue, it's grant compliance. The grants compliance issue is really, in my mind, going to come down to dealing with the counties. You are going to have to force compliance with a separate agency that's funded at the county level and require them to comply with certain grant requirements. I'm fairly familiar with this whole problem with grant compliance, and it is onerous. I mean, it's a big lift. So I would like to see this thing does move forward here, just how that's going to be accomplished. How are you planning to work with the individual counties in a way that gets grant compliance for the grants you may be trying to, you know, help their programs out, your programs. Thank you, Madam Co-Chair.
Further discussion. Representative Zwanitzer.
As part, if the motion goes through, I would just kind of direct LSO the basic questions of at what level is it treated at in the Department of Health now? I assume it's a program manager, level 10 probably. What a standard grant writer position is. And so I guess I'm looking at the cost of employees because it takes people to go after these grants and write them and do compliance. I don't see a difference in funding to the programs or the counties per se on where the change comes from. The funding would come on if we get more federal money, or if the state legislature, we look at it in our next meeting and say, we probably should be funding these more out of either general fund or tobacco settlement. We've been attacking that fund for a while, but those are the kind of the questions I think moves the discussion forward. Like Representative Washit said, is we need to know the current costs specifically, and then what we believe it would take to do that extra level of funding. We pony up 25% of it for 2 more positions, and we believe we can get 10 million in grants. So if LSO could work with ANI on kind of what those positions would need to be that we think the Supreme Court would need to have a grant person, et cetera, and how it would work in either agency. And I think we're have better information then to decide.
Mr. Fuller.
Yeah, Madam Chairman, a couple comments in that regard. First, in terms of a fiscal note, for various reasons, mostly because we're unable to do fiscal notes on proposed bills before they reach a formal stage. Just generally, it's highly unlikely we'd be able to do the same for this particular bill. I think we could certainly find information regarding what positions have been allocated, and I'm not sure about what costs. We'll look into that. In terms of standard information, I think we could probably find that out for various positions. The caveat being is that I think it's ultimately up to the committee and the various agencies to present their views in terms of what positions, what types of positions should be included in this proposed transition.
Thank you, Mr. Fuller. I do think that the court will come forward with that information at our next meeting. I'm seeing Ms. Butler nod. And the Department of Health Director will also come forward, I think, probably with some additional insight. So there's a motion on the floor. In the committee. Further discussion on the motion? Senator Cost.
Thank you, Madam Chair. The other thing that the draft will hopefully show us will be, are there any personnel within the health department that would be moved over because they are in charge of the drug courts or whatever. So we'll get to find a lot of information out. We did something similar with agriculture when we moved it. It's a deep process, but at least when we find the data and know what we're dealing with, we can make a better decision. So by going this direction, I'm hoping that the data will help to drive us in what's best for the program.
Further discussion. Question having been called, all those in favor, please say aye. Any opposed? No.
No.
Motion has passed. All right, committee, any other topics along this? We did hear from Mr. Volk about, this is just a topic for consideration, juveniles needing the consent of parents for treatment courts. Any consideration there? All right, seeing none, we're gonna move on. Do you want to take a 5-minute break? Take a quick 5-minute break and come back at 4:15. All right, Joint Judiciary Committee, welcome back. We have some amazing news here today. Our one and only Senator French is here in Lander, Wyoming at the Joint Judiciary Committee when he should be celebrating his 47th wedding anniversary. Wonderful congratulations to Senator French. Senator French.
Madam Chair, I told my wife I would take her out. And she said, oh, great. And that was this morning. I said, I'll take you out and show you how to operate the barbecue. So you can cook me some supper when I get home. And that didn't go over real well.
And that's why he's staying in Lander tonight. All right. And is grateful our meeting is going long. All right. So with that, again, congratulations, Senator French, quite an achievement, 47 years. Well. So it's hard to transition to the next subject from that, but we're going to go ahead and try. House Bill 85, Child Endangering Controlled Substance Abuse While Pregnant. Representative Amber Oakley is here to discuss her bill. And for the public and the committee's consideration, the bullet point for 24/7, we're going to go ahead and skip that this time and maybe look at it later when we have a little bit more information ready to go for a meeting. So with that, we'll go to House Bill 85.
Good afternoon, committee. I did not know I was going to be doing this right now.
You've done it before, it's fine.
Yeah, I'm good. Okay, so in discussing House Bill 85, I've obviously presented that to you all in House Judiciary, Senate Judiciary, on the floor. So I'm just going to start. I mean, you all know what it is. It's making it a crime to ingest methamphetamine or a controlled substance, a Schedule 1 or 2 narcotic drug while pregnant. And in looking at that, so it was radically different in front of the committees and in front of the House and Senate. So it easily passed the 2/3 to be heard last session in the House. And then I think it was 47 to 13 or something like that, it passed. And then it went down in flames in the Senate and in grand fashion from what I hear. So I actually think this is a good time to take from this cast discussion, because when I heard pushback about it, it seemed to be that there was this notion that probation and substance abuse treatment don't work for people. So I can't think of a better time to start this discussion again on the heels of what we just heard, which is, let's see, Ms. Goggles said the effectiveness of treatment courts, the judges are very key to that. Judge Christensen said, you know, what we're looking at is individuals one at a time who are becoming productive members of society. It was said these programs are the way to do it as far as rehabilitation for people with these substance abuse issues. And Director Johansson said the intensity of supervision is really what translates to success. The entire point of this bill is to take something that we know is extremely dangerous, extremely costly, lifelong consequences for children who are born after this proposed crime, and asking to connect that with treatment. In fact, because of the concerns that I heard, we specifically added that it is mandated to do probation and treatment on a first offense. As I said, I don't think that exists anywhere else in our criminal statutes. But the whole point, and when I've talked to people, people said, well, certainly that's already illegal. But It's not, because the cases that we've had were, we charged under child endangering. This is an addition to the child endangering statute. Was dismissed because child was defined, is defined, and it's after birth. So rather than, I'm not going to try to redefine what the word child means, just prohibit the conduct that we're talking about, which is, of course, ingesting these dangerous drugs that causes birth defects and all sorts of long-term consequences for a child, and say that is prohibited behavior. I think that people in Wyoming would want that to be prohibited conduct. So that's what the criminal statute is. I mean, you know, looking today, I got such a pushback because it would add to the felony, the 5-year felony child endangering statute is where it is currently proposed. But we've talked about making it a felony, you know, even went to like yelling at referees or, and today, even though they're tragic accidents, this is willful conduct done by people doing something that they already know is illegal. And they also know there isn't anybody that doesn't know the devastating consequences of this when they do that action. So I think it's appropriate that it would be illegal and that we connect it with the treatment, all these wonderful programs that we talk about having. That is what people do via the criminal justice system, is we hold them accountable and then they go get treatment. And it has some of the highest success rates. I was talking to a counselor after, a forensic counselor in Fremont County. And he said, let's do what we can to get this passed. And I think he said his group's official opinion had to be that he was against it. But he said, this is the way that people get it right, is when you attach it with the criminal justice system. And he said, I see better results this way than any other way. And again, we just heard a long discussion about it, which I think it is, again, I think that was fantastic when we talked, we need more information, more data, more statistics. I look forward to that because I believe that we will find that it will be a great benefit to our community to attach this treatment piece to this. And I do think it should be prohibited illegal conduct. And I stand for questions.
Thank you, Representative. Questions for the representative? Representative Provenza.
Thank you, Madam Chairwoman. Representative Oakley, is it already illegal to use methamphetamine while pregnant in other ways?
Representative Oakley.
Thank you, Madam Chair. As this committee is well aware, it's a misdemeanor to use methamphetamine. Use of methamphetamine is never enhanceable to a felony. It's a 6-month misdemeanor. Possession of drugs can be enhanceable, or is enhanceable, or can be, on a third or subsequent.
Further questions from the committee? Representative Provenza.
Thank you, Madam Chairwoman. And so part of my question is then, if we heard that these drug courts or these treatment courts do such a good job and that they're more effective than just the justice system, and the point of the legislation was to treat people, then can we skip the process of providing a felony to someone that will bar them from job opportunities, housing opportunities, and other things that lead to increased recidivism, get them into treatment court? And how can we also not just make it, can we make it not just pregnant women and make it people who are struggling with addiction, because we know this is substance abuse disorder? I mean, are you opposed to just skipping that part of the criminality? Because part of the issue that we've talked about this a lot, I think the paper said that we sparred. So here we are again. But that concern of just, if there's a criminal component to it, if we're specifically making pregnancy and substance abuse another issue, women are more likely in other states to then end up not seeking the treatment that they need. And it's already a stigmatized act. And so what we need is to be able to protect infants from having more issues with mom beforehand. not necessarily coming at the end, like we've talked about in other discussions in the past 2 days. Let's solve the root problem, not come behind with maybe that punitive measure, which I agree, substance use treatment is great. I don't necessarily think we have to further criminalize the act, which has the detrimental outcomes. Are you open to that?
Madam Chair, Representative Provenza. Basically, what I just heard from you is everybody who needs substance, who has a substance abuse issue should get treatment, and I can wholeheartedly agree. They don't have to go through the criminal justice system. Anybody can go get themselves to, realize they have a problem and check themselves in at any point. This doesn't preclude that. But then at the beginning of your question, you talked about, the treatment courts and CAST, they are court assisted treatment. I mean, that's what that is. So, I think you greatly broadened the scope to all substance abuse. Okay, but that's not what we're talking about. This is about, whether this should be a criminal act, and I think that it should. And then what I think is it adds this accountability piece that I keep talking about, which is what treatment courts do, is they add that accountability, which we heard from, like I said, I gave some quotes from everybody who spoke as far as that is part of the success. That is part of some of these people getting it right because they're held accountable in a much higher level. But if people want to get treatment, of course.
Representative Washit.
Thank you, Madam Chair. There's nothing in this bill draft, am I correct, that would preclude a prosecutor from utilizing the first offender 301 status in appropriate cases, correct?
Representative Oakley.
Madam Chair, Representative Washit, that's absolutely correct. And I think this probably would be something, when you start looking at your 5-year felonies, if and when 301s are used in felonies, it's often your lower level. So yes, they could absolutely do a deferral and avoid a conviction. And also, again, then go through these treatment programs and through court assisted treatment. And I do want to say, I thought of this just for some parity. It's a 5-year felony just to have methamphetamine in the same room as a child. But not to ingest it when, you're physically connected with this child. You understand it, but in the same statute, it's illegal because we recognize the dangers just to have a child in the same room or the same vehicle as methamphetamine.
Senator French.
Thank you, Madam Chair. Is there any concern that this woman that's using meth, that she may be scared to go to the doctor, that, she'll be reported and that, she won't properly get services for that pregnancy? Is there a worry that she may say, gosh, if I go to have my checkup and see how baby's doing and everything, that if I'm reported, God, I'm in big trouble. Do you have any worry about that kind of thing?
Madam Chair. Thank you, Senator French. So that's a great question, and it's certainly part of the discussion. That is used as one of the arguments against this. I tend to say that I don't think there's going to be that sophisticated of a analysis at that level. Some disagree with that, but I think also important with that is to note that there's not mandatory reporting attached with this. So I think maybe healthcare workers would choose not to report it. I can say that the 2 cases that have been dismissed in Fremont County, it was actually it was from the blood of a child that was born. But you know, it was from when she ingested when she was pregnant. So that was, but you were talking a fully, I mean, a delivered child was how this was discovered. She continued, you know, throughout her pregnancy and until she delivered.
All right. Senators and representatives, Joint Judiciary Committee, it is 4:35. This is a bill we have heard before. So I want to just keep your questions pointed so we don't rehash maybe some of the same debates that we had before and just do a second bite at the apple. Because I think when we took this issue up as an interim, it was out of a kind of a joint conversation about the need to address the concern that we as a state do not want to you know, have a policy where there's no accountability for women who use, but also recognizing that there are significant ramifications and unintended consequences for maybe the felony route. And so having a more robust conversation about those different options available to us. So with that, let's hold our questions for the representative. We'll come back to the bill and then hear maybe some public testimony on maybe some alternative options that I know was discussed in, during the session about hearing from some of the stakeholders. I don't see many of them here in the room today. Do we have anybody online? That was maybe going to discuss how different states chose to respond to this concern so that maybe we can provide a solution there as well. Folks online?
Madam Chairman, we have Jan Cartwright online.
All right, let's go ahead and is she the only one here for this bill?
Yes.
Let's go ahead and bring in Ms. Cartwright and then we'll get to the rest of the room. And who in the audience is prepared to provide some comments on this bill? Go ahead and come forward. We'll just put you at the table and have you ready to go next. And in light of the hour, want to be as efficient as possible.
Madam Chair, members of the committee, before I start, I do know that Ms. Somerville with WAMSAC is also wanting to comment on this, and she is on her way back. My name is Lindsay, and I am with the Wyoming Counseling Association. We are very excited when it comes to offering additional services for people who are pregnant and may be using. The part that gives us heartburn is the 5-year child endangerment clause. As far as the desire to create accountability, we believe that 12 months within drug court, being supervised by a judge, will do that for these women who are using while pregnant. As we discussed within the interim, the majority of those women already have children within the home. And so removing them from the home is not ideal and also causes more trauma to the family system. Where the conflict is happening is in the sentence of willfully, they are engaging in willful conduct by those who know what they are doing is wrong. For those of us within mental health and within addiction treatment, we recognize that addiction is a disease. We recognize that many times that willfulness is not necessarily as coherent as it is with somebody who's not struggling with addiction. And therefore, we would like to pursue the treatment and the accountability that drug court has to offer for these people. And I stand for questions.
Any questions? All right, thank you. With that, we're going to go to Ms. Cartwright. Ms. Cartwright, thanks for being here online. The floor is yours, so go ahead and unmute yourself and happy to hear from you.
Thank you, Madam Chairman. I'm Jan Cartwright, representing the Wyoming Public Health Association. Thanks for this opportunity to make brief comments on this topic. There are important health considerations from this bill that impacts women most likely who are already underserved. Pregnant women in Wyoming smoke at one of the highest rates in the country based on CDC reporting. And in my experience, my experience includes working with medication-assisted treatment or MAT providers who have helped people, including pregnant women, stop opioids, which is a brave and complicated undertaking for pregnant women. Pregnant women's substance use disorder is primarily a mental health issue, and it has real world implications for them and their babies. I agree. It is also a public health concern when women who are pregnant do not seek care for fear of being charged with a crime. And I would say that this would be for women. Underserved women tend to be reactionary to things, and I think that this would be a huge hurdle for them, has been brought up. I know this isn't a new argument, but it has to be considered by this committee and others who are looking at maternal health issues. Thank you, Madam Chairman.
Thank you, Ms. Cartwright. Questions for Ms. Cartwright? All right, appreciate you being here in your testimony today.
Thank you.
All right. Mr. Craig, please proceed.
Thank you, Madam Chair. My name is Frank Craig. I'm State Director for the Gateway Foundation. We're a nonprofit that contracts to the Wyoming Department of Corrections Substance Use Services, also and the President of Wyoming Association of Addiction Professionals. As I'm looking through the revision of this bill, as we had discussed before, I just wanted to point out a few things. If the committee should entertain moving forward with that, that maybe need to be considered as well. Within the first 5 lines of the bill, and as was previously mentioned, that there's not a provision for tobacco use or alcohol use as well. And we know that historically alcohol is the primary substance abused. So are we just going to say that that's okay? They can drink and smoke all they want to, but just don't use methamphetamines or other class 1 or class 2 scheduled drugs. Also in line 4, we're talking about prescribed medications as kind of an exclusion unless prescribed by licensed healthcare professions. We also know that opioids is one of the major addictions that is actually supported by prescribed medications. And when I say supported, I mean in an abusive manner, of course. If you were to entertain that, you might consider using terms such as taken as prescribed by a licensed healthcare professional. Moving down to line 10, and this is just an observation with the fact that we're looking at potentially an abortion Roe versus Wade overturn. It's a hot topic now, but it looks like that this bill would recognize that a fetus is actually a person. And the implications that may or may not have, depending on whatever you believe about that. But I would also be remiss if I didn't point out, in addition to a deterrent for seeking prenatal care as an option, as Senator French pointed out, that it could also be a motive for the mother to terminate the pregnancy. To avoid that kind of involvement in the criminal justice system as a concern as well. If you look down in lines 14 and 17, just a concern that there's a specifically named assessment tool, the ASI. There's a variety of different assessment tools that could be used to determine if somebody has a substance use disorder and to what severity level that would be. I might suggest that the specific kind of tool would be removed out of that language to give an assessment option for providers as well. The intent of the bill, as I understand it, is to avoid going further into the criminal justice system by providing a treatment option for a first offense. And I would just like to point out in my experience that many times somebody that's really suffering a substance use disorder is maybe not responsive to that initial intervention and will likely end up that the person violates and is revoked and has to go to prison anyway. So I'm not sure that's a good resolution. In particular, as I spoke to in the last topic, if we're not able to provide resources to provide the correct dosage of treatment at that time, then that again is a setup for failure and maybe leading to incarceration in the prison. If you have a stage 3 cancer and the only treatment available is a stage 1 treatment, that's probably not going to work. And that's kind of the limited resources that we have, even considering drug court. And we know that works, but I'm just saying about half of our reincarcerations, are because of a violation for probation or parole. And with that, I'd stand for any questions.
Thank you. Thank you very much for that testimony and really the right way of how to testify on a very specific bill, of going through for the committee areas of the bill that are of concern. So it draws our attention to it and we can provide solutions and address those. So perfect type of testimony to be given, and appreciate that. All right. Ms. Forsland, welcome.
Thank you, Madam Chair. Obviously, we're tag teaming here on the WAP side of things. Cheryl Foland, legislative advocate for the Wyoming Association of Addictions Professionals, and I'm also a private provider in Rawlins, which does not have the luxury of a drug court in Carbon County. One of the things that I would like to point out that Mr. Craig did recognize was, in fact, that according to the RAND study that was done in 2019, the laws that punish pregnant drug abusers aren't working across the United States for a variety of reasons. One of the things that we would like to do is open the discussions on what will work, why it will work, and providing those resources. Right now, there are 6 provisional providers in Rawlins, in Carbon County, and there are 3 fully licensed providers. That's what we have for our entire county. We're not the only ones. We respect our partners at the community mental health centers, and that's where 1/3 of our provisional people are in Carbon County. We don't have the staffing, we don't have the service providers who are adequately trained and properly trained to work with these individuals. The other concern of this bill is it comes from, when do we identify the pregnant woman? In most of the studies that have come out of the National Institutes of Health right now, especially in rural and western states, we're finding that it's upon delivery. These women are not seeking prenatal care because they're afraid. The doctors in Carbon County, and unfortunately, as many of you may know, we have lost our labor and delivery at our hospital. We don't have it. The women have to go to Laramie. They have to go to Rock Springs, anywhere other than Rawlins. So now these women are going to be in Laramie. They're going to be identified. Their babies will be identified as testing positive. The National Institute of Health and Health and Human Services just released studies that alcohol and tobacco are number 1 and number 2 for substances that infants test positive for. The third is marijuana. None of those 3 items are even part of this discussion. And they too have the long-term complications for children. As Mr. Craig said, we certainly have options that we would like to discuss in moving forward. We do not believe that criminalizing women for an addiction problem is the right way to go. We would prefer to put resources, as has been identified by the CDC, the National Institutes of Health, and Health and Human Services, to go expending money which costs less on the front end and working with these women before they even recognize that they're pregnant. Thank you, Madam Chair.
Thank you. All right. Thank you. Further public comment? Welcome, Mr. McNevin.
Madam Chairman, members of the committee, my name is Travis McNiven on behalf and with the Northern Arapahoe Business Council. Today, I'd like to introduce three members. We have council members Jared Whitebull and Kim Harjo, as well as Sunny Goggles Duran, who spoke earlier today. I will certainly turn the time over to them, but on a high level, wanted to, in instructions with the chairwoman, address the concerns with the 5 years, and then also provide some other additional thoughts for some states that may be looked at for additional ideas. And so with that, I will turn it over to who would like to go first? Okay, go ahead.
Guess I got selected first, Madam Chairwoman. Notice how they all looked at me, but yeah.
You do a great job.
My name is again Sunny Goggles Duran, and I am the director of White Buffalo Recovery Center. I also am a foster parent, and I have 2 drug-affected children that I raise. I've raised one child since he's been 8 months old. He has numerous issues due to his mother's substance abuse, including methamphetamine, alcohol, opiates, and marijuana. I come to you as a parent because he still loves his mother. His mother is a loving mother and has raised 2 other children before she was consumed by her addiction. And I know my child, my little boy, really does need his mom, and she needs the services that will help her. I wanted to bring up some of the things, as mentioned before, you know, if somebody does violate, in the case of my son's mother, she went to residential treatment. She walked away from treatment when she was 6 months pregnant, and she left that facility. We just happened to run into her at another time, and she had run into one of our peer staff, and we brought her back into our recovery home because she was not willing to go to inpatient treatment. She stayed sober for 2 months upon term of carrying this little boy, and he was born drug and alcohol free in those 2 months' time. Unfortunately, there was a lot of damage that was already done to this little boy, and that is something that I have dedicated my life to work with him on. But one of the things I really want to do is consider the fact that she is still a human, she's still a human being, and she is still a very loving mother that unfortunately, because her life has been consumed by addiction, she cannot take care of this child. And I'm very thankful that he is with me. So I just wanted to add that. In that sense, if she was to leave the treatment center on her own accord, she would have been sent back to prison with this current bill in progress, you know, depending on what would happen. And so she would have delivered this little boy in prison rather than in treatment. If you send somebody with an addiction problem into jail, they leave jail with an addiction problem. There is not a lot of services in the judicial system, in the criminal or the correctional facilities for treatment services. And unfortunately, the big reality is there is a lot of substance abuse within our criminal justice system. There's a lot of substance use in our prisons, and a lot of our people are still using while they're in prison. So I want you to consider that too. They do need to get treatment, and until somebody gets treatment services, that addiction is going to stay with them no matter how long you put them in jail, whether it be a year, whether it be 5 years. And so that's something to consider. The other thought I had was maybe looking at some civil prosecution versus criminal. That has worked with other states. And then there's also the concept of civil prosecution with involuntary commitment, just in the sense that some other states have done, involuntarily committing an expectant mother. So that's another consideration. I really do want to emphasize, though, that both my children that I take care of, neither one of their parents had gotten prenatal care during their pregnancies. The only time they got prenatal care was upon delivery for my little girl, who tested positive for Wellbutrin and methamphetamine when she was born. And I had to sit with her while she went through her withdrawals after her mom left her at the hospital, awaiting and fearful of somebody coming and taking her to jail. So she left her child at the hospital, who's an amazing, beautiful little girl. Her name is Cora. And my other child, Joaquin, his mother also, I don't think she would have got any other services. They could have gotten a little bit more services. We didn't know that he had some developmental issues. He does not have fingers on one side of his hand. He only has one finger on the other side. He has amniotic banding. He had a cleft palate, cleft lip, and several issues. And so he did not get any prenatal care until he was born, which required him to get flown out. The only prenatal care he did receive was when he was in our residential home. So I just wanted to bring that up too, that we don't want to deter these parents from getting the medical necessary prenatal care that they have. And I don't know if medical providers would be comfortable saying, I have to report this, knowing that they probably won't come back to them for services.
Afternoon. Yeah, I don't want to, repeat, something that's had stated already, but, a lot of things, with this bill, if it does progress, there's a guarantee of a higher percentage of people getting scared and not seeking any services at all. Due to the fact that, this is my second offense, I'm going to prison for 5 years or up to 5 years. So it's really crucial that, we all have the same goal of trying to help people. We're elected in these positions for a reason. And we have a job and duty to the communities that we serve. So it's our obligation to find these solutions, the universal solution to help our people, our communities, to grow, to expand. And another issues that would be bringing up too is for the success rate for the individuals that do succeed in recovery, to get back into school or apply for housing, or it would really burden them with a felony charge on them. They would have to, because when I was taking courses at CBC while I was working for White Buffalo, I started as a peer working there. I was studying to get my CAFA license. And some of the individuals in my classes, they were recovering addicts as well. And then I, just sparked up a conversation with one of them, and they had to pay out of pocket because they couldn't qualify for a Pell Grant or any educational scholarships. So they're, we're trying to maintain their sobriety, their recovery, but due to the stress of trying to do better, some of them end up dropping out, unfortunately. But it's our obligation to our communities to try to help our people, not punish our people, regardless if they're tribal or non-tribal. We have a duty to them, to try to help us grow and expand and help conquer, all these issues that we face on a daily basis, as a community, as a county, as a state, as a nation. So, it would be really hurtful if we, to the individuals that are in recovery. Because a lot of people, when we all deal with stress, and we all have our breaking points. And unfortunately, people that are suffering through addiction, they have a shorter fuse, I guess. They are more susceptible of returning back to their old ways of using. So, thank you.
Thank you. Yeah, please go ahead.
My name is Councilwoman Harjo. I was glad to come to this session today. For me, with the drug court, which was before this session, I think this bill that Representative Oakley brought forth would really do good in a drug court. I think that they would have that supervised provision for the mothers. And as was discussed before, they had brought in other people that were addicted. And I think that if we really start pushing the drug court, our drug court was real successful when we first had it. Right now, we were state funded at first. Now we are not, but we're still continuing to fund our drug court with various grants, whatever monies that we can get from private institutions. And I think that they really would not go and look for medical help while they're pregnant. It just won't happen. And I think there is some good things in this bill, but one of the things that we have to look is how we're going to put it together, how we're going to put it together to keep it going, to make sure that our mothers aren't addicted when they do have their babies. So that's what I wanted to say about the drug court and with the methamphetamine. We were targeted on the Wind River Reservation. We have a lot of methamphetamine. You can see that the family structure has broken down a lot. So I think that together, working in collaboration with each other, we can kick this, we can get it done. But it's going to take all of us to do it, not just a few here and there. It's going to take all of us to get this done with our future children that are coming up. It's really sad that the state that our nation is in right now, methamphetamine across the nation, no matter what it is. Now it's fentanyl. So there's things that we need to do and things that we need to talk about. Thank you.
Thank you for being here. Yeah, go ahead.
I just want to make one more comment. Just like Councilwoman Harjo has stated, you know, we don't have to punish our people, but you know, as long as we collaborate and bring in different ideas, different point of views to find this common solution that are not just our state, but throughout the nation is dealing with, you know, as long as we, you know, team up and find that universal solution so that way we can kind of work together to grow. So thank you again.
Really appreciate you being here. Thanks for taking care of Joaquin and Cora. Really a courageous thing to do. So thank you for that sacrifice and pretty remarkable story. Appreciate it. Questions from the committee? You guys okay? All right. Thank you both, for all of you. Further public comment? Welcome back, Ms. Somerville.
Thank you, Madam Chairman. Andy Somerville, Executive Director for WAMSAC. And I want to concentrate today just on two specific points because I know you've all heard a lot of testimony on this bill previously. First is, since this session, I've had an opportunity to do some investigation into what other states are currently have on the books in regards to this issue. Tennessee is the only state that I could find with a law where it specifically criminalizes substance use with pregnant women. There are similar laws in 2 other of the southern states. There are a number of states that, 18 specifically, that state that substance use during pregnancy is child abuse, which can be handled criminally or can be handled administratively with DFS or such like agency. But overwhelmingly, what I found in my research is that even in states like Utah and Texas, they're moving the other direction, which is instead of criminalizing, they are trying to offer more supportive services, mandating that doctors perform early intervention screenings, things along those lines. So that's what I've seen in my research. The second piece that I wanted to hit on was just kind of a high level of what we provided to the legislature during the session, which is the concern that we have for this bill is we're not sure that it's the right policy first, and have serious questions about, you know, driving women underground instead of into services. But second, we have serious concerns about the unfunded mandate and the impact it'll have to the system that we have in Wyoming right now. So we currently have 3 centers in the state that have specific beds for what we call parenting women. These are women that are pregnant or women that come with young children for substance abuse treatment. 21 total in the entire state. They are located in Sheridan, Casper, and Rock Springs. Those beds usually have a waiting list. And sometimes that waiting list is 6 months long. And certainly, so we already have an overwhelming demand for the scant resources that we have already. We projected, based on the numbers that DFS was able to provide a few months ago, of 113 women being clearly identified as would fall in this category and potentially mandated into treatment. That would cost an initial state of Wyoming somewhere between $8 and $10 million investment, plus ongoing investment to provide for the services going forward. Again, I feel like a broken record here, but I want to remind the committee, House Bill 38 did pass 2 years ago, and families at risk is now a tier 1 priority population that has to be served by the community mental health centers. We certainly don't want to create a system where we have women that are waiting 6 months to a year, you know, to access beds because we don't have them. And so we would still appreciate some substantial discussion regarding what the state expects from the community mental health system to provide these beds, how it's going to be funded going forward, and how we can improve those services so that we're not creating a situation where women are sitting in jail or something awaiting a treatment bed. So with that, I would stand for any other questions.
Questions from Ms. Somerville? Not seeing any, Andy. Thank you much for
Thank
being here. Other public comment? Or you have a question, Representative Provenza?
Yeah, thank you, Co-Chairman. One of the things I want to ask about is I know that there are several different movements right now to take care, to investigate this further in terms of what are the solutions for Wyoming. And I know, my understanding is that either Department of Health or Department of Family Services just received a grant to kind of look into this further with help of SAMHSA, I believe. And so I'm wondering, I mean, if anybody can confirm that, that would, it sounds like Ms. Fullen can confirm that and maybe tell us a little bit about what that initiative is doing. Thank you.
Ms. Fullen, welcome back. The floor is yours.
Thank you, Mr. Chair, committee members. I am very privileged to sit on a steering committee that is from the Department of Family Services, has in fact received a grant along with the Department of Health, and Mr. Johansson can probably give some more detail. Dr. Bush is certainly one of the driving members of this, and it is a federal initiative called the Plans of Safe Care. And the purpose of this grant is to look at prevention and look at giving services to women in those early stages when they are either just finding out they're pregnant or they're finding out they're pregnant later into term. But it's a collaborative effort between the Department of Family Services, the Department of Health, private stakeholders like myself, providers of substance abuse and mental health treatment. And it certainly will benefit the entire state because it's going to be from all medical healthcare providers in the state that treat pregnant women, not just the OBGYNs, but the family docs as well. And it is about doing those early interventions, those assessments, and finding out what is this woman's risk? Is she currently using? Is it a past issue for her? So we are taking a brand new look at this, and I commend those two departments, Mr. Johansson's department and Department of Family Services, for stepping up and getting this in place. I will tell you that we're not actually doing anything yet as far as providing services. We are at the level of defining what we're going to do, how it's going to look, what assessment tools we're going to use, and bring in whoever else we need.
Representative Provenza, good? Okay. While Ms. Fullen's up, any questions? Okay, any other public comment? Anyone else online? Oh, coming back second time. We'll make it quick since some of us have a long drive home. Welcome back.
One other thing I wanted to add was when we talked about treatment. So we all know that treatment for substance abuse is really high. And I really do believe that if we use a drug court, that cost would stay down. So I'm really sold on the drug courts. I've seen it work where we live. We've had a lot of good success rates there. So I think that if we tie Representative Oakley's bill to something in the drug court, I think that we would have a really good outcome. Thank you.
All right, thank you. Any additional public comment? Anyone else online? We're good? All right. With that, public comment is closed. Committee, back to you. Representative Rodriguez-Williams.
Thank you, Madam Chairman. I move that the committee adopt House Bill 85 as written during the previous session by Representative Oakley's bill.
Is there a second? Seconded by Senator Cooper. Further discussion? Representative Provenza.
Thank you, Madam Chairwoman. As we heard, it sounds like there's a large initiative to try and solve this problem, to try and figure out how do we protect infants, children, how do we ensure that we stop the core issue? I know that Labor and Health has also considered this as a topic as well. They're spending an entire morning on it. And I think that's where this belongs. I don't like, I understand the want to tie it to the drug court system, and maybe we can look for solutions to do that when we talk about it with the current statutes that we have, or how can we maybe tweak them, not make it a felony. Because I do think that's a huge concern here. We don't have the resources. We don't have the beds. And so let's talk about how to, let's find out what the people who know the answers are going to find. And then maybe let's reconsider this, but I think we're jumping the gun here. And really we're putting women in a terrible position if we continue down this path.
Further discussion, Senator Cooper.
Thank you, Madam Chair. I'm kind of confused by a couple of the folks who came up to testify here a little bit ago. They were telling us what a wonderful thing the treatment court is, and then come up here and testify against a bill that goes hand in hand with the treatment court. I guess I'm confused by the lack of consistency in their testimony. I see this bill as a real positive thing for the treatment court. It's built for it, if you will. Is there a point where we need to take the felony provisions out of it? Possibly, maybe even probably. But I think it's time to move forward with this bill with the thought of how it works so well with the treatment courts. And we heard a lot of testimony, especially from the Arapaho group, that the treatment courts do work. I think it's a great fit. Thank you.
Further discussion? Senator Kolb.
Thank you, Madam Co-Chair. We heard this during the session, and it's an issue. I think clearly all the testimony states there's an issue. The question is just how we're going to handle it. I think Representative Oakley's bill goes a long way in that conversation, and I look forward to modifying, maybe having a conversation about what changes we maybe need to make. But this is not the first thing that would happen to anybody. This is a safety net for the unborn. Simply that. If all else fails, what else are we going to do? I understand consequences. I understand that. I think I've heard a lot of testimony. I really do appreciate it. But this bill merely affords a level of protection we currently don't have. And we can all agree what we currently have doesn't work. So I think we should work the bill and see what we can come out of it with, after the end of the discussion. Thank you, Ms. Co-Chair.
Representative Rodriguez-Williams.
Thank you, Madam Chairman. I just like to reiterate the question that the bringer of the bill brought forward earlier. And it's a big question. Why is it not okay to have meth in the same room as a baby, but it's okay to have meth absorbed into a baby's body? I believe the state has an obligation to keep vulnerable people safe, and I think this bill solves the problem.
Representative Washut.
Thank you, Madam Chair. I think we heard testimony that there was an abusing mom who didn't seek medical prenatal care for her baby, even though we don't have this law. Okay. And I just wonder, maybe the Department of Health or others might generate some data for us in terms of how many abusing moms seek prenatal care now. And, we do worry. I think it's a genuine concern that abusing moms don't get any prenatal care, but I'm not sure they're getting prenatal care now. And so I think that this bill is the right thing to do.
Further discussion? Question being called. All those in favor, recognizing the history as it's passed both of these committees before. All those in favor, please say aye.
Aye.
All those opposed say no. No. That bill has passed. All right, committee. That topic is closed. We're now going to go to bill drafts. Dissolution of county boards amendments. As you recall, this bill is this issue is a joint judiciary bill that we had in the interim that was amended on the House floor, and a concurrence committee happened after great debate. I think the House tried to, I don't know what they did. Lots of controversy over the ability to dissolve county created boards. But Mr. Fuller, it looks like maybe we need an amendment to it. So if you could walk us through.
Yep, Madam Chairman, members of the committee, this bill, which will be 23 LSO 1, is to correct a technical correction. This 2022 Senate File 27 that this committee sponsored. There was a House amendment that deleted from the bill the authority for counties to dissolve boards of trustees for archaeological, geological, and historical museums. The reference on page 2, line 2, was not included in that amendment. So this bill simply strikes that reference to conform with that House amendment.
Committee questions for Mr. Fuller? All right, seeing none. Questions for Mr. Fuller? Representative Craigo?
Madam Chairman, just a quick question for Mr. Fuller. So I'm gathering it's a cleanup. Technical correction.
Yep. Madam Chairman, Representative Craigo, that's correct. Technical correction. The one thing I would note, the question may be, why not the reviser's bill? I think there is a question about the language that's used there. Each board of county commissioners may dissolve any board created under that statute, that it arguably may be of substance, even if it is just a technical correction.
Further questions for Mr. Fuller? All right, any public comment on this proposed amendment, cleanup amendment? I'm seeing none. Committee, back to you. I need a motion.
Madam Chairman, my apologies. We do have Mr. Riemann.
Okay, great. Mr. Riemann, great to see you.
Good evening, Madam Chairwoman, members of the committee. I'm Jeremiah Riemann here on behalf of the County Commissioners Association. I think we all do agree that this is a cleanup bill to clarify what the House did. So I'm not here to debate that particular piece, but being the paranoid that I can be and that I'm paid to be, I would request one simple change to the bill, and that's actually in the title, to ensure that this bill, as it isn't in the reviser's bill, doesn't become a clarification bill for other entities to seek their inclusion in it. So all I'm requesting is that the committee consider adding in archaeological, geological, and historical museum after dissolve in the title of the bill. And with that, Madam Chairwoman, I would stand for any questions.
Mr. Riemann, it sounds like maybe you've done this before. All right, Mr. Fuller, comments?
Yep, Madam Chairman. One note with that, the catch title, and for technological reasons, we are limited to 60 characters for that. So it would be difficult to fit all of that in there. The catch title, though, is just a means of notice and a short title for the bill. I would note on lines 2 and 3 in the bill title, which does have a kind of a constitutional nexus in terms of amending a bill beyond its title. That is the reference to the bill title. And lines 1 through 3, clarifying that boards of county commissioners do not have authority to dissolve archaeological, geological, and historical museums under its general authority to dissolve county created boards and commissions. So I did try to draft that bill title quite narrowly to only make sure that it only captures that correction.
Mr. Riemann, are you comfortable with Mr. Fuller? I always am.
Madam Chairwoman, I would defer to Mr. Fuller. My simple attempt here is to ensure that this is only specific to that. And again, I would defer to him on that.
All right, thank you, Mr. Riemann. All right, committee, I need a motion. Representative Provenza.
I would motion to bring the bill draft forward as a committee bill.
All right, seconded by Senator Koss. Further discussion? Seeing none, all those in favor say aye. Any opposed? Representatives one answer, is it no? No.
And Madam Chairman, just to clarify, this bill is drafted, even though it does not have an LSO number, it is drafted in LSO form. So I think the question would be if you just want to advance this to the next meeting or vote to sponsor this as a committee bill.
Somebody moved to sponsor it as a committee bill. Representative Provenza, do you move to sponsor it as a committee bill?
I do, Madam Chairwoman. I thought that was my intention the first one, so I motion to move this as a committee bill for the 2023 general session.
Great, and that's my mistake. Thank you. Senator Cost seconds it. Roll call vote.
Madam Chairman, this is a roll call vote to sponsor 23 LSO 1. Senator Cooper.
Aye.
Senator French. Senator Kolb. Senator Cost.
Aye.
Representative Craigo. Representative Larson.
Aye.
Representative Oakley. Representative Provenza.
Aye.
Representative Washit.
Aye.
Representative Rodriguez Williams. Representative Yen. Representative Swanitzer. Co-Chairman Olson. Chairwoman Nethercott.
Committee, we will go to the next issue, which is probate court filing fee. Mr. Fuller, if you want to give us an overview of this.
Yep, Madam Chairman, members of the committee, this will be 23 LSO 2 probate court original filing fee. This was a bill draft that the chairman requested to be prepared for this meeting. And what it does is goes into 2-2-401, which establishes the original filing fee for probate actions and changes that fee from $110 to $120. This would be in line with the district court filing fee. That language is on the bottom of page 2 in the staff comment. All the staff comment does is just notes the different language that is used in the probate filing fee statute in 2-2-401 and the language used in the district court fees in 53206 for purposes of where certain fees, how those are calculated for the probate and district court fees. But the only change in the bill is on page 2, line 1, to change that probate filing fee to $120.
Questions for Mr. Fuller? District Court clerks, any comments on this particular bill draft? What's that? Oh, Miss Butler, I'm sorry. But you both can come forward. I think that's okay for where we're at.
Madam Chairwoman, members of the committee, my name is Elise Butler. I'm the State Court Administrator for the Wyoming Supreme Court. One of the things I think that the intention of this bill, and Clerk Sutton can back me up here, hopefully, or not. But one of the intentions of this bill is to marry the two filing fees together. So there's a civil court filing fee and there's a probate court filing fee. And right now they are different. And that makes it a little bit confusing for attorneys. And then as we move towards e-filing, it will become even more confusing. And so we really want to marry these two bills up, or these two fees up. One of the things that I saw in looking at the bill is because of the difference in the language in the civil filing fee statute and the probate filing fee statute, what this actually does is it brings that filing fee further apart. If you put on page 2, line 1, if that fee is 120, because in the probate filing fee, what happens is $120, that base fee on line 1 on page 2 is the fee that goes to the county. It goes to the clerk's office. And then in the probate, it adds on $40 for the judicial systems automation fee, and then $10 for the civil legal services fee. The distinction is in the civil filing fee, what happens is it says $120, and of that $120, 40 will go to JSA and 10 will go to CLS, meaning that the clerk's office gets $70 and the JSA special revenue account gets 40. And does that make sense? So if you wanted to actually marry those two bills up, there's a couple of different ways that you could do that. One would be to raise in 53206 would be to increase that fee in the civil filing fee realm. Or the other way would be to reduce on page 2, line 1, that original filing fee to $70 instead of $120. And so Clerk Sutton can say her piece here, but I think that was my only point, is if the intent really is to marry those two fees up, this needs to be finagled a little bit.
Questions for Ms. Butler? All right, Clerk Sutton.
Thank you, Madam Chairwoman Ann Sutton, Teton County Clerk of District Court. Ms. Butler, I think, well explained how the filing fees work and why they may be confusing in both the statute and then in the assessment of them on the front line. The Clerks of District Court Association will be meeting in 2 weeks. This will be a topic of their discussion. I think there's support for some consistency. As Ms. Butler said, there's probably two approaches to that. Either the reduction in the probate fee or an increase in the civil fee. I would just comment that I anticipate some of the discussion much of the discussion at the Clerks of District Court Association meeting could include a concern about drawing back a fee that's already exists and taking that away and reducing that. So I'm sure there'll be a robust discussion about perhaps a preference for pairing them together by bringing up the civil fee by that $40. That would match them. It would make it easier to administer, easier for filers to know what fee applies to which type of case. The other thing I just want to take the opportunity to mention every time we talk about filing fees is to make sure it's clear that while some of these filing fees do come to the counties, I just checked my fiscal year 23 budget request, which is to the county, which is $726,548. Of that, I project that $20,000 will be collected by filing fees as they are today. So what I want to share is that's 3% of our budget. So while we do talk about filing fees in any context, please know that while they are a revenue stream for the county, they are a very small revenue stream for the county. But we will be back before you, I expect, in your September meeting after that Clerk of District Court Association discussion to have perhaps a more officially approved position by the association as a whole to what we would like to see and request as far as statutory cleanup.
Thank you, Clerk Sutton. Representative Washit.
Thank you, Madam Chair. Given what we just heard, I'm going to introduce a motion to table until the September meeting, further discussion of this bill, and we'll get the final testimony from the Clerks Association and can move forward.
Well, it's non-debatable. Move to table. All those in favor say aye.
Aye.
All those opposed, no. It's tabled. Okay. Any additional actions from the committee? I think we've got one coming. Representative Craigo, you raising your hand?
Madam Chairman, just a point of clarification, I guess, maybe for the committee and as well for LSO on House Bill 85. Representative Rodriguez Williams moved that we adopt that bill. We took a voice vote. Is that, I mean, are we forwarding that as a committee bill? And if so, do we need to take roll call?
We're forwarding that to the next meeting.
Okay, thank you.
That's done. Representative Zwanitzer, do you have a motion?
Yes, Madam Chairman, for a bill draft, and it's an interesting issue that came up in my county. But I would move, and I can explain if I get a second, for LSO to draft a bill. It's in statute 91802B. It's our qualifications for district attorney statutes. And so we have a line that says what the bill draft would be to strike immediately prior to his election when it comes to qualifications of district attorneys. And so, as I think many of you know, we have an odd issue in Laramie County involving the current district attorney and potential disbarment from being a lawyer, and then the qualifications on if you have to be in good standing with the bar to run for that office and to serve in that office, what happens in the middle of your term? You no longer have that qualification. And so we just I would ask the committee some diligence to have a bill draft and that to be hopefully briefly discussed at our next meeting. But it's a weird
current-
area of law.
Yeah, the current statute regarding the qualifications for a district attorney recognize they have to be in good standing in order to qualify to be elected as a district attorney. But the statute is somewhat ambiguous about what happens if one is not in good standing or is not licensed after elected and in an office. And so Representative Zwanitzer has a motion to clarify what is likely the legislative intent originally associated with it, that in order to either be elected or to continue to serve in the role of district attorney, that you are not disbarred.
Madam Chairman, I don't know if I have a second yet. We could take it up in corporations, but it does seem more like a judiciary issue.
So that was moved by Representative Zwanitzer, seconded by Senator Kolb. Discussion? Seeing none, all those in favor say aye.
Aye.
Any opposed? All right, that motion has passed. Any further public comment for the good of the order? All right, members of the Joint Judiciary Committee, we've done a remarkable job these last 2 days. We did a bunch of work. I think we have great work ahead of us in the interim. I think we're really cooking with gas again, and I want to thank you for your time and attention. Again, congratulations to Senator French on 47 years. Drive safely home. Hopefully that grill is cold. Thank you to LSO for all the wonderful research and assistance. Do you want to go over any last actions, Mr. Fuller? Hold tight.
Madam Chairman, I think the only question is if you'd like me to run through the list of committee actions over the past 2 days.
Let's do it. Make sure
Okay.
everyone's clear. There was some confusion at the end that I just awarded.
Okay, so the committee voted for bill drafts to bring back 2022 House Bill 103, which was the game and fish trespass bill with modifications, a bill draft to repeal subsection C in both the civil and criminal data trespass statutes, a bill draft that would prohibit drone use over Department of Correction facility or correctional facilities for contraband with the option of addressing those drones through capture or destruction. A bill draft to define aircrafts to include drones in the criminal code. A bill draft, excuse me, in the game and fish trespass statute, a bill draft to adopt restatement 159 as a misdemeanor offense. Memos regarding drones for voyeurism, an aircraft definition in the criminal code in terms of vehicles and that definition in the criminal code. A memo looking at the laws of other states for financial exploitation, as well as our Adult Protection Act. And then bill drafts, one for assault against healthcare workers, a bill draft to amend the references to the guardian ad litem program to conform to the new office, a bill draft to update the presumptive child support tables, one to add state park rangers to law enforcement retirement, a bill draft to increase the clerk of district court bond to a minimum $100,000, a memo regarding the constitutional origins of the clerk and district court, a bill draft for homicide by vehicle in a crosswalk or school zone, a bill draft to bring back 2022 House Bill 38 concerning non-compete clauses, a bill draft to clarify the jurisdiction based on Rosen, a bill draft to clarify in Schneider that a hearing for an interlock device removal is at the court's discretion, a bill draft to move drug courts to the judicial branch from the Department of Health, a bill draft to resurrect 2022 House Bill 85 engrossed, which was the child endangerment. The committee voted to sponsor 23 LSO 1 for the county boards, and then a bill draft to amend 91802B regarding the district attorney qualifications.
Mr. Fuller, thank you. Appreciate that. Appreciate all your diligence. Again, thank you, LSO. Thank you to everyone who's hung with us for these last 2 days. Appreciate seeing you.